Court will come to order. Members, the motion made, you asked if there are any statements from this witness. Are there any statements from this witness you have not turned over? No, Your Honor. Okay. The only thing you have are work product notes? That's all we have. All right. Okay. Be at the microphone, please.
There are no statements from this witness. We have notes that we have are our mental processes and everything as to what he said in summary of different things and issues, but no notes and no notes have any statement from the witness. If
there are any statements you discover, they need to be turned over.
That's absolutely right.
All right. Motion's denied.
Yes, Judge.
Bailiff will call the witness in.
Thank you. Oh.
No, you're still under oath from yesterday, Mr. Bangert. Please be seated. Counselor, you can continue.
Good morning. Oops.
Good morning.
Thank you. I want to go, if I can, back a little bit from where we broke up yesterday, back to the Mitty Foundation issue and your involvement in that. After the intervention that you've testified about on June the 2nd of 2020, did the Attorney General contact you personally about that issue again?
We did have conversations subsequent to the intervention, yes.
All right. And what was the occasion? Did you attend any meeting with the Attorney General about it?
I did attend a meeting with him. We were having a senior staff meeting. We had a weekly meeting every week where all of the deputies would gather in the main conference room, and he did request my presence at a off-site meeting to discuss the Mitty Foundation.
Can you give us a time?
The meetings happened in the morning, roughly mid-morning. It was, I believe, after the intervention, but it was prior to my being removed from the case by First Assistant Mateer.
All right. So what did he say? Just if you could repeat what he said to you and asked for.
He came to me in the meeting. The meeting had already started. He approached me and said, "I need you to come with me to lunch."
And did he say any further? Who was the lunch going to be with?
Nate Paul.
What did he say to you as to why he wanted you to go to lunch with Nate Paul?
He didn't say specifically at that time. He just said we needed to go and have lunch with Nate Paul.
Did he indicate why he wanted you to go to lunch with Nate Paul?
It became clear subsequent to that what the meeting was about, yes.
What was your position at that time that you had stated to him before the intervention and even at the time of the intervention as to whether you were opposed or unopposed to it?
I was very uncomfortable with the intervention. We had discussed it. There were ongoing conversations after the intervention that made me even more uncomfortable with our position in that case. And I had communicated to him what I believe were the pros and cons, and we were very heavy on the con side.
So where did you go to lunch?
I believe it was Polvo's. It was a Mexican restaurant downtown.
And who went to the lunch with you?
Well, it was, we had to go through some gymnastics to even make the lunch happen. It was with the Attorney General and Drew Wicker from the Attorney General's office, and Nate Paul, of course.
How many weeks after the intervention and after you had expressed your opposition to it, How many weeks after that would this luncheon have been?
It would have been 1 to 2 weeks after is my best guess. I can't tell you precisely, but it was sometime in mid-June. It was very warm.
Did he ever ask you to go to lunch with anybody that represented the Mitty Foundation?
No.
Did he ever ask you to go to lunch with the lawyers representing the Mitty Foundation?
No.
In the entire litigation that had been going on for several years, did he ever ask you to meet with anybody other than Nate Paul, one of the parties to the litigation?
In connection with that case, no.
All right. Now, when you arrived at lunch, can you describe the lunch for us, please?
The Attorney General drove us over to Nate Paul's office, which is not far from our office, and left his car there. And as I recall, we piled into Nate Paul's car, and then he drove to Polvo's.
As a lawyer, what was your reaction to being asked? Did you consider it an ask or a directive? Let me ask you that first.
Objection, relevance.
I've simply asked you. I've given him a choice. I'm not telling which is
Overruled. You can ask the question.
Thank you.
It was not a request to which I could say no for reasons that I can explain.
Please.
The reasons why were Jeff Mateer and I discussed briefly the request that I go to lunch with Nate Paul. And we very quickly determined that it would be inappropriate.
Objection to hearsay. He's talking about a conversation with Jeff Mateer.
Let me re-ask it a certain way if I can. Thank you,
Please
Your Honor.
sustain that and re-ask.
Thank you very much. All right. Let's go back now to apparently more happened on their initial request. Let's go back to when, at the meeting, he wanted you to go to lunch with Nate Paul. What was your initial reaction when he asked you that?
I was concerned that I was being asked to meet with the principal of a party in a lawsuit to which we had intervened.
And so without going into what Mr. Mateer and you said, who did you go to talk to?
I visited with the Attorney General, and I explained to him that there were ethical concerns because as counsel for the state of Texas, I would be meeting with a represented party in a lawsuit to which the state of Texas had intervened.
So what did you ask to him if you could do, and what did you do?
I explained to him
Objection to
that
hearsay.
What? It's not. It's a conversation with the Attorney General.
It's this
Overruled.
I explained to the Attorney General that the only way that we could properly make this work under the rules of ethics is if there was a waiver from Nate Paul's counsel allowing me to speak directly with a represented party. My assumption was that that would terminate the request and we could go back to the meeting.
So was that the course that you took after you privately consulted with Mr. Mateer?
Yes.
All right. And then when you told the Attorney General that, what did he do?
He went back to his office for a short amount of time and emerged with a document that purported to be a written waiver from Nate Paul's counsel, giving me permission to meet with Nate Paul without his lawyers present.
Mr. Banger, how long did it take the Attorney General of the state of Texas to go into his office, contact the counsel for Nate Paul, and get a document prepared that waived any objection that lawyer would have to you talking directly to Mr. Paul?
Objection, speculation. This witness doesn't know what Mr. Paxton did in his office.
The question was how long it took.
Overruled.
Thank you. Excuse me. Thank you.
No more than 15 minutes.
And what was the document he brought it back to you in 15 minutes?
My recollection is it was a document that had been faxed or emailed to him. It was not something that I believe he would prepared. The appearance of it was not something that he would have prepared. But it was a document that had been prepared by one of Nate Paul's lawyers, waiving any conflicts that might arise from me as counsel for the state of Texas, meeting with a represented party.
All right. Well, after that process and all, did you feel free to decline the lunch meeting, or what was your reaction? What did you do?
Well, I told Mr. Mateer that he had gotten a waiver, and I was pretty much straight out of luck at that point. I had to go.
Now, when you went to Mr. Paul's office, where was his office, by the way?
It was in downtown Austin, south of here, but I don't recall specifically the location.
And when you went, I mean, you guys actually went and got in his office and got in his car and went in his car?
We went and parked in his parking lot and got in his car.
Describe the lunch for us. Where, did you sit in a public area or a private area or what?
We went to Polvo's. Yeah, I recall the layout of the restaurant. It was Polvo's downtown. We went into the restaurant. If I recall correctly, Nate Paul wanted to sit outside, even though it was warm. So we sat out on the porch. It was very uncrowded. There weren't many people there. And we sat down for lunch.
And how did the conversation go? Did Mr. Paxton introduce the subject, or did you introduce it, or did somebody else do it?
I was not entirely sure why I was there, but it became very clear. Nate Paul, in the moment we sat down.
Objection, non-responsive.
I'll take care of it. Thank you, Judge. If it's okay, I'll
Sustain and continue.
Thank you very much. Who was the first person to speak, if you recall?
Nate Paul did almost all of the talking.
Did the Attorney General do any kind of introduction or anything? What was his role in this conversation?
It was nothing more than, Ryan, this is Nate Paul, and there are some things he'd like you to hear. That was effectively the upshot of it.
There was something, he said what?
I'm paraphrasing now, but it was to the effect of, this is Nate Paul, and he has some things to share with you.
So then what did Mr. Paul do?
He proceeded to lay out his theory of the case.
Objection, hearsay. He's talking about a statement by Nate Paul.
Sustained.
Did the Attorney General during this entire conversation reject anything that Mr. Paul was saying?
No.
Did the Attorney General of the state of Texas do anything to show that he did not agree with the things that Mr. Paul was saying?
No.
So once again, this conversation with Mr. Paul that was had in the presence of the Attorney General, what did Mr. Paul say?
Objection, hearsay.
Your Honor, the reason for this is all in the presence of the party, the Attorney General, and his silence or his statements are acquiescence in adopting the statements of Mr. Paul. That's why I don't believe that it is subject to the hearsay exception.
Judge, permission to respond?
Respond.
There is no evidence that this witness can talk about that Mr. Paxton has adopted any statements made by Mr. Paul during that conversation. And because of that, it is not a statement that is adopted by a party opponent, and for that reason, it's still hearsay. Any statement by Nate Paul is hearsay at that meeting.
Overruled. Continue.
Thank you. What did he say?
Mr. Paul laid out his theory of grievances against the Mitty Foundation. He described to me how unfair it was that a charity that was a limited investor would be able to assume control over assets that were owned by World Class. He was very vehemently opposed to the receivership. He, as I recall, was more or less railing on the way that Ray Chester and the counsel for Mitty Foundation had handled the case, and more or less went through a number of different complaints that had been raised in a memorandum that had been provided to me by his sister, Sheena Paul.
I think it'll become clear in later testimony from others, but Sheena Paul is a lawyer. Is that correct?
Yes.
And she's the sister of Mr. Nate Paul.
That's correct.
But your familiarity with the case, had she been actively involved in the litigation on behalf of her brother?
I don't know how actively involved she was. My impression was she was involved as general in-house counsel for World Class, yes.
All right, fair enough. How long did this description of his complaints and his position with by Mr. Paul, how long did that last?
Oh, the lunch lasted for a good 30, 35 minutes, if not 40.
Did you
Somewhere
folks
in that
have
range.
Did you folks have food?
We did order food. I don't think I ate very much.
Did the Attorney General during this meeting ever reject or try to modify or ask questions or do anything during the time that Mr. Paul was pleading his case to you?
He did not, no.
How did the luncheon end?
Mr. Paul completed his exposition, and that was a signal for the lunch to end.
Did you ask any questions?
I may have asked a few questions, I don't recall, but it very much had the feeling that I had been summoned to a lunch.
Objection, non-responsive.
Excuse me. I don't know whether it was or not. I don't know what the answer was.
Sustain the objection, rephrase, please.
Thank you. What was your impression about that, what that whole meeting was about?
The strong impression that I had developed was I had been summoned to that lunch by Nate Paul to hear out his grievances and to convince me to get on board with the Midi Foundation intervention program.
So how did it, once it ended, what did y'all do?
We parted ways, drove back, got back in the Attorney General's car, and came back to the office.
Did the Attorney General say anything to you about the case after y'all left Mr. Paul at his office?
Very little.
Did y'all just sort of sit there silently?
As I recall, it was a very quiet ride back, yes.
And was Mr. Wicker present for this whole conversation?
He was, yes.
Did you talk to Mr. Wicker about that after you came back?
I did.
All right. And did you yourself express yourself as to what you thought about the lunch?
Yes, I did.
What'd you say?
Objection, hearsay.
This man is here. It's not hearsay. A statement by the witness, Your Honor, is not.
Overruled.
Thank you. What did you say?
I told him, Drew, that was one of the craziest things I've ever seen.
His response?
Objection, hearsay.
Okay, thank you.
Sustained.
All right. Thank you, Your Honor. Thank you, Your Honor. We'll move on. Now, let me, how old were you at that time of that conversation?
How old was
How
I?
old were you in the summer of 2020?
I was 42 or 43. I'm trying to do the math in my head. 42, I believe.
How long had you been a lawyer?
I had been a lawyer since, for about 15. Well, I think I was 43 now that you mention it, because I'm doing the math. I was 43. And I had been a lawyer for the better part of 15 years at least.
Had you ever, in 15 years as a lawyer, experienced anything like that?
Objection to relevance and an improper opinion, Judge.
I'm just asking him if he's experienced, he ever had anything similar as a lawyer.
Overruled. Continue.
Go ahead.
It was, as we say in the Latin, sui generis. It was one of a kind. I'd never seen anything like it.
All right. Now, I can, if, by the way, there is one fact I want to try to move on to another subject. But at this time that y'all are spending this time dealing with Mr. Paul's issues, what all is going on in the Attorney General's office as far as real work that you guys, women, were responsible for doing? What's happening on the landscape in the state of Texas and in the Attorney General's office that y'all wanted to be working on?
We were working around the clock on COVID-related issues, and we were also preparing a major multi-state lawsuit against Google.
And is that Google lawsuit still pending?
As far as I know, it is.
But has it since been given to an outside law firm?
Yes,
At the time you were there, was it being handled in-house or by an outside law firm?
in-house.
Right. Did it remain being handled inside the firm, inside the agency, until after all of you resigned or were fired?
Objection, this witness doesn't have personal knowledge of that.
Let me put it this way. Of the people that left on the top floor that were all terminated ultimately, the 8, what people have called colloquially the 8 whistleblowers, was Google ultimately farmed out to a private law firm after all of y'all were gone?
Objection, hearsay. Objection, lack of personal knowledge.
Hearsay is
Overruled.
Thank you.
I believe more than one law firm, yes.
Pardon me?
I believe more than one, yes, outside firms.
Now, the microphone, I can't tell, I don't know whether it's being picked up behind me, so if you could just maybe, if it's louder to me, then maybe it'll be louder back there, okay? In addition to Google, were there other major pieces of litigation going on that you were responsible for?
Yes, there were.
What?
The special litigation unit was very busy handling a number of election-related lawsuits.
All right. And were there other areas? What was y'all's experience or involvement at that time in trying to cope with COVID-related legal issues?
We had a section called the Disaster Council Advice section under the General Counsel that was handling a flood of requests from local officials as to how to handle COVID.
Well, when the Attorney General kept raising Nate Paul issues of the ones that we've gone through so far and later in the future, do you have any idea how much time or resources that were devoted to dealing with Nate Paul instead of real concerns?
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
Can you put any kind of quantifying amount on it as you sit there?
Well, certainly the opinion that we discussed yesterday consumed the better part of 3 days of my time that could have been spent working on other matters. And of course, the Mitty Foundation consumed a lot more time than that.
Now, I want to ask you if I can, and then of course we haven't gotten to whatever time was expended on the hiring of somebody purportedly being a special prosecutor. In other words, the hiring of an outside counsel. We haven't even discussed that.
Objection to attorney testifying.
Excuse me, let me finish my question, please.
Judge, my objection is to the call of his question.
Counsel, let him finish.
Yes, Judge.
And then you can object. Mr. Hardin, you can finish your question.
Thank you. Do you have any idea how much more time and resources were devoted to once you discovered this issue of an outside counsel being considered and then being done?
It was many, many hours. We spent days dealing with the fallout of that, and that was all of us together. So 7, 8 of us at least, plus a few support staff. So it'd be hundreds of man hours.
All right, now, Mr. Bangert, I want to go to, you mentioned what some of us colloquially have called the midnight opinion. Can you tell us, without not necessarily a long legal description, is there a section in the government code that deals with these opinions?
There is a very distinct section in the government code that deals with our authority to issue opinions, yes.
All right. So when we talk about opinions, very briefly, that come out of the Attorney General's office, how many types of opinions would you say there are involved?
There are a handful of types of opinions involved. The first would be an opinion issued pursuant to our government code 402 authority to issue opinions to individuals who are authorized requesters.
All right, let me stop there. So Section 402 of the government code authorizes you to produce opinions in response to whom?
Very specific individuals. There's a list in the code. Chairmen of legislative committees are one. Certain statewide officials. There are a handful, I believe, of local government officials who would be authorized, but it's a very distinct list, and that list cannot be waived.
And is there any distinction in the government code between an informal and a formal opinion?
No.
Do you recall whether or not in the opinion that y'all wrote at the Attorney General's request, do you recall any language at the end of it that talked about it was an informal opinion guidance? Can I put up, do we have an exhibit number for, can I step over there just to get an exhibit number, please?
Yes, sir.
Thank you. Stacy, can I ask you to put up Exhibit 115, which is in evidence? And can we go to the end of that opinion, please? Well, first of all, do you recognize...
Counselor, has this already on the list of admitted evidence?
This has already been admitted.
It has been. Okay.
Yes, this is one that's agreed. Thank you, Your Honor. But do you recognize this exhibit?
I do.
And what is it?
The first page, this is the opinion that we worked on and issued August 1st in response to the Attorney General's request concerning foreclosures.
All right. And this is the opinion you've talked about earlier that was completed at about 1 o'clock in the morning on that Sunday?
It is.
All right. Now, if you would, Stacey, would you scroll to sort of the end of the opinion? Now, could you explain to us, I believe you just testified there's not a difference, there's not a distinction in the code between informal and formal?
And Judge, I'd object that that is an improper legal conclusion by this witness.
What? I'm
Overruled.
Sorry. Thank you. This opinion that you drafted, and this is actually an opinion that you signed, correct?
Yes.
And was this division and this matter under your supervision and control?
It had been.
All right. Before you became the deputy first assistant, is that what you mean?
Yes.
Okay. All right. So the language says, I'm trying to stay with the microphone to be able to read. It says, please note, this letter is not a formal Attorney General opinion under Section 402.042 of the Texas Government Code. Rather, it is intended only to convey informal legal guidance. Explain to me what the significance of that is, and is that inconsistent with your previous testimony?
No, it is not.
All right, explain, please.
Well, I would analogize this to the practice in Texas courts of issuing published and unpublished opinions. We have an obligation under 402.045, which is part of the opinions authority, only to issue opinions to individuals if they are authorized requesters. You cannot simply issue opinions as the Attorney General's office to any individual who asks, because we are not a private law firm. We serve the interest of the state.
So if I walk in off the street or have something in my business or so that I really want an opinion for, am I entitled to ask the Attorney General's office to give me an opinion, just to give me the legal advice?
No, not unless you're one of the listed statutory requesters.
Is a legislator one of those people that is authorized to ask?
Chairman, yes.
All right. And it has to be a chairman of a committee?
Yes.
And in this case, as we've talked about yesterday, that's what happened, correct?
Yes, I believe Senator Hughes at this time was chair of the State Affairs Committee and possibly one other.
All right. Now, was there a time in the history of the Attorney General's office in which the office did issue informal opinions?
My recollection was that, yes, there was a time when we would post opinions on our website that were informal in nature.
All right. And are you aware that your website, their website now, the Attorney General's website now, indicates that stopped in 1979? Is that anywhere consistent with your understanding?
That would not surprise me.
All right. Now, go here to explain to me why you put this language in here then that said, it's not a formal Attorney General opinion. It is intended only to convey informal legal guidance. Explain why that's okay, or why you put it there either.
Yes. The normal opinions process involves going through the opinion committee. It's a very rigorous process of drafting, review, approval. It goes up through a number of different layers of review. This did not follow that normal process. It did not go out for briefing for third parties to evaluate and consider whether they wanted to brief on this. So none of those procedural aspects were associated with this opinion, nor did it receive what we call a KP number, which is a formal opinion assignment number for publication on the website and ultimately publication on Westlaw.
Well, as far as the statute is concerned, is there a distinction by what you did on this opinion that night any different? Is that opinion and its consequences any different than in terms of its effects on the outside world?
Objection.
Excuse me, let me finish my question. If I could remember what it was, let me start over. Is there any difference on the impact on the outside world of what you did here in this particular opinion and what an opinion that you might have issued that went through the formal process that you say takes up to 6 months or so?
No, all of our opinions have persuasive
Objection.
value.
Improper legal opinion.
Overruled. Continue.
Why did you say that then?
This signaled to the reader that this opinion had not gone through the formal, rigorous process of review by the opinion committee. It had not gone out for briefing. It had not gone through the normal process that can take up to 180 days of time. And it was also not going to be receiving a KP number. And I don't believe this is published on Westlaw. I haven't checked, but I would be surprised if it were.
So why did the two of you decide to do it this way, to put that sentence in there? Would you ordinarily have put that sentence in an opinion where, say, another chairman of another committee asked for it, et cetera? Would you have ordinarily put this sentence in there?
We would not put this sentence in an opinion that went through the normal, formal process. There were other opinions that contained this language, but all of them had similar characteristics. They were requested by someone who was an authorized requester, and they did not go through the formal process.
And does that not going through the formal process and you're communicating that to the outside world, is there a reason you do that?
This signals that it did not receive the rigorous review that an opinion of our office normally would.
So if lawyers in court are contesting having a controversial issue and their opposing side sought to introduce this, is that sort of a signal to anybody that knew about the process that they might have an argument to the judge? Wait a minute, this is not, there's no such thing, may not be such a thing as an informal opinion, Judge, but this opinion did not go through the rigorous process a normal opinion did. Would that argument be available to him?
I presume it would be. Certainly our intent was to signal this had not gone through the formal process.
All right. I notice your eyebrows go up when you're thinking. Does that mean that you never had thought about it before I just asked this?
Oh, no, this is something that we were dealing with en masse.
Objection. Non-responsive. There wasn't a question asked.
Okay.
Sustained.
Were you having these kind of questions all the time? Or not all the time. Let me put it another way. Were you frequently having to deal with this kind of issue?
At this time, this specific moment, we were dealing with an unusual influx of requests for advice.
And was there a process in which you could provide, are there other ways that you could provide, other than just this? Could you do things in another way, like press releases or things like that?
Certainly, if we're not providing legal advice to an individual, we can send out press statements, we can send out bulletins or announcements. I don't see anything that would preclude us from doing this, but the code 402045 is very clear that if we're providing advice to an individual, then that individual must be an authorized requester for the purpose of ensuring that the interests of the state are being represented by that request.
Are you aware, one way or the other, whether opinions like this might be used by litigants in private litigation?
I assume they are, because that's why they are posted on
Objection.
Westlaw.
Speculation. This witness was not there for the litigants.
I would,
Overruled.
Your Honor, I'm going to ask if the court might, I'd say this nicely, instruct counsel when he has an objection to wait until the answer is completed, and then he can object and ask for some, if the court sustains it, he can ask for other things. But this constant interrupting the witness in the middle of the statement or the questioner in the middle of the statement is unduly time-consuming.
Your Honor, may I respond to that?
Yes.
I have to object if the witness is testifying to things that shouldn't be admissible into evidence. I shouldn't have to wait for him to say hearsay before I make that objection. And so I would request to wait till Mr. Hardin finishes his question and then lodge my objection.
If you're talking over each other, the court reporters can't report accurately what either of you are saying. and the jurors can't hear what you're saying. So I understand, Counselor, but try to not talk over each other.
Yes, Judge.
Thank you, Your Honor. Excuse me. Now, real quickly, and we're about through with this issue, but I want to know if there are other ways that y'all chose to inform people. For instance, if mayors, what was your experience during this period of time, if mayors of cities or local government spokespersons or officers were contacting you for legal guidance, how did you approach those kind of issues in dealing with COVID?
Yes. The legislature had granted our office authority under Section 418 to respond to requests for legal advice from certain local officials, mayors are one of them, for issues related to a declared disaster in their jurisdiction. That code was passed, my understanding, in response to hurricane disasters. No one anticipated every single county in the state of Texas being placed under a simultaneous disaster declaration in response to COVID, but so it was. So we effectively became available to officials in 254 counties throughout the state of Texas under 418.
Do you have any knowledge one way or the other through discussions and activities in the Attorney General's office as to whether or not the Attorney General had indicated he was aware of other possible ways to address someone's concern about a gathering other than Section 402?
Unless there was an authorized requester under 418, no.
All right, thank you. Now, at the end of the day, once this process was completed, was there any distinction in however it would be considered by others in this opinion and the opinion that went through the very rigorous 6 months of research and consultation?
The effect is the same. They have persuasive value based on the solidness of the reasoning and based on the fact that it's issued by the Attorney General's office. It's the persuasive value of the opinion that follows it.
Thank you. Now, when we can, I want to go to one final question. Is an opinion under this Section 402 that you issued, is it considered just as authoritative, though, in terms of its results, as an opinion that goes through the rigorous examination that you described?
There's no reason it would not.
Okay. Now, would it have the same ability and the same impact if one wanted to seek to use it in litigation?
Again, the reader would evaluate it for its persuasive value, just like a formal opinion.
All right. Now, I want to move, if I may, sir, to what happens starting in your experience. When did you become, with the outside counsel, when did you become aware that the Lieutenant Governor wanted to appoint outside counsel?
Senator, Counselor, I almost called you Senator, so we're even.
You know, I've done it again.
Yeah. I'm going to be forced to hold you in contempt soon, Harold. Just kidding. Just kidding.
I'm just thankful I didn't put a name to it.
So am I. So go ahead.
All right. Let me start again. When did you first become aware that the Attorney General was interested in and concerned and wanted an outside lawyer hired to deal with an investigation of Mr. Paul's complaints?
Action leading.
I don't.
Overruled.
It would have been sometime in August or September that I learned about the outside counsel request.
All right, there we have seen one that talks about the matrix that such a request would have to go through. Were you aware that Mr. Vassar had drafted a contract at the request of the Attorney General's office before, and if so, when did you become aware of that?
I was aware of that, yes.
And had you taken a position about whether or not to hire an outside counsel?
With the Attorney General,
And
no.
your microphone.
I had not, but I obviously in conversations, I should say obviously, in conversations with other senior staff, we were very much in agreement. This
Objection
is
to
not a proper.
hearsay. Objection to hearsay.
He hasn't. See, that's the problem with doing it. He did not talk about what they said. He did not talk about any statement. And this interruption of the question keeps it from being clear as to what he was going to say. That's my concern.
Overruled.
Thank you. So, and the question was your position.
Improper.
All right. And do you recall when's the first time you told the Attorney General that yourself?
I did not have occasion to speak with him about this, as it was outside my line of authority.
All right. So your opposition that you thought you were opposed to it, would that been communicated to others rather than the Attorney General?
Objection, hearsay.
I'm sorry, what was the answer?
I'm objecting, and I would ask for a ruling, Judge.
Counsel, you're talking over him that I can't even distinguish what you're objecting to, what he said or what he said. So let's start over on that question.
Sure. Thank you, Judge. Were your conversations, without going into what they were, about this subject with other people rather than the Attorney General?
Yes.
Objection. Okay.
Overruled.
Yes.
Thank you. Now, at the end of when did this, from your perspective, when did this issue boil over?
When you say boil over, could you be more specific?
Yeah, if you could, again, it sounded to me like you moved away from the microphone a little bit.
Mr.
Just
Banger, you could speak a little louder, I think.
Yeah,
Speak up a little bit more.
Thank you very much. All right. I didn't know that moved. Okay.
I think I might have broken it, so
All right.
hopefully not.
So don't mess with the base of it very much, or we can both get in trouble. When I used the phrase boil over, let me explain what I mean in my question. What I mean is, when did this become an issue of concern to more than just one person in the criminal justice division that you became aware of? What time frame is all I'm asking you?
Increasingly through August and into September, it became an issue of very urgent concern for me, as well as for others on the senior leadership team.
All right. Now, tell me what it was, in fact, when did this issue first surface, and what matter did it surface that gave you concern?
When you say the matter, it would be with regards to Nate Paul?
Yes.
My concerns had been growing exponentially over the 9 to 10 month period that we were dealing with matters related to Nate Paul. It began when I was asked to intervene and work with the open records requests. It was uncharacteristic. It continued and was heightened when I was asked to work on the Mitty Foundation project. I was exceptionally concerned after the opinion was issued, because I felt there had been a break in trust at that point. And of course, when I became aware that the Attorney General is now pressing for criminal investigation of individuals in the community based on allegations that all of us believed, and I certainly believed, were frivolous at best, I was exceptionally concerned.
Now, without going into what other people told you at the time in a specific conversation, did you become aware of generally the subject area or so that the Attorney General was seeking to hire outside counsel to investigate?
Yes, it involved the law enforcement action concerning Nate Paul and his properties. He was concerned that this was his same mantra over and over again.
When you say he, are you talking about the Attorney General?
Well, Nate Paul, and in connection with the Attorney General, arguing that law enforcement had been wronging Nate Paul, had been oppressing Nate Paul, and had been treating him unlawfully. There was no evidence that I had seen whatsoever to substantiate any of that.
Judge, I would object to that. It's an improper opinion. It's speculation, and this witness doesn't have personal knowledge of Nate Paul's opinions or feelings at that time.
He's expressing his opinion of what gave him concern on an evolving way, Your Honor.
Counselor, I think he's expressing his opinion, so overruled.
Yes, Judge.
Now, when exactly did you start getting involved in expressing your position and taking your position on this matter?
We were discussing it actively throughout the month of September.
All right. Now, at the time, were you aware one way or the other that Mr. Penley was refusing to sign the contract that had been drafted by Mr. Vassar to retain Mr. Kamek?
Yes.
Though it had not made its way to you, had you seen the contract that was proposed?
I do not recall, although I had certainly discussed it with others.
Did you, in fact, take any position in these meetings, you yourself, of senior staff, on the advisability of hiring Mr. Kamek to go investigate multiple public law enforcement persons? Did you?
Yes.
And what were you saying? What was your position?
Objection, hearsay.
It is not hearsay. There is no hearsay for the witness on the
Overruled.
stand.
Counselor, he's asking him for his opinion.
Okay.
What was your position?
There was no basis or justification for it. It would not serve the public interest.
And if you had to describe the opinion of about how many of you were involved in this issue at the senior level?
Jeff Mateer, I was aware of it. David Maxwell, Mark Penley. I am Ryan Vassar, obviously. Lacey Mays, because she was working with Mr. Vassar, and Blake Brickman as policy would have been involved as well.
By the way, you've essentially named the group of 8 whistleblowers, have you not?
I don't believe I named Darren McCarty.
All right. And was he one of those that was also concerned?
He was, although his focus was primarily civil.
All right. Now, I don't think I asked, maybe if I did, I want to be clear. Have you sued in this case?
I have not sued the Attorney General, no.
And so as we look and listen to people in this testimony, Mr. Mateer and you both, neither one of you have sued or sought any damages or compensation. Is that correct?
I have not sued, and I am aware that Mr. Mateer has not either.
All right. Now, when how did this thing come to a crescendo, if it did? When you talk about the first week in September, what events were you aware of that affected what happened at the end of September?
I was in Atlanta, Georgia, at a conference with Mr. Mateer. We were about to join a significant telephone call with our multi-state partners to discuss the Google litigation that was planned. The call was set to begin. It was a very important call for coalition building purposes. Mr. Mateer received a telephone call. It was from the Attorney General, and I was witness to Mr. Mateer's side of the call. The call had nothing to do with Google. It was all about Nate Paul.
And at that time, how big an issue and a matter and piece of litigation was the Google case in the Attorney General's office?
It was consuming substantial resources and was a major initiative of the Attorney General's office, and it was, yes.
Did you two inform the Attorney General you were about to go into an important meeting on Google?
Yes.
What did you say?
Mr. Mateer was the one communicating directly with the Attorney General, but something to the effect of, do we have to do this now, because we're about to have this Google conversation?
What was the Attorney General's response?
I could not hear his response, but the phone call continued for some time, so I have to assume his response was yes, we have to.
All right, his objection is to you assuming, and I agree with that. Don't assume what happened, but as a result, even though the Attorney General was told that you were about to be involved in a meeting on a very major piece of civil litigation, did he terminate the call to talk later?
No, it continued for some
Objection
time.
to speculation. He couldn't hear Ken Paxton on the phone.
Counselor, he asked if he terminated the call. Continue.
Thank you.
Overruled.
Thank you. Now, this conversation that lasted, were you part of it in terms of being able to respond and hear the Attorney General?
I could not hear the Attorney General, nor could I respond to him.
Could you hear the conversation in response by Mr. Mateer?
Yes.
And the conversation lasted again about how long?
We went right up to the bell. We were almost late for the Google call. It probably took about 10 minutes.
Your Honor, I would urge that this conversation, which was happening between the two of them, is actually not hearsay in the sense the content of what the Attorney General was saying, or what Mr. Mateer was saying, rather, not offered for the truth of the matter of what he was saying about Nate Paul, but only that that's what he was telling these folks. And so I would like to tender conversations as to what he was having with Mr. Mateer as they were talking.
Hold one second, Counselor.
Sure.
Was there I don't think there was an objection. You were starting this line of questioning.
Only because I didn't want to speak over anybody, but I am objecting to this line of questioning, and I do have a response if the court would care to hear it.
What is your response?
Well, that Mr. Bangert has already testified that he could not hear Ken Paxton on the other side of that phone call. So he can't testify to this court that he's adopted any of the statements made by Mr. Mateer. Mr. Hardin wants to submit Mr. Mateer's testimony. That's not made in court. That's hearsay.
If I may I ask counsel, I didn't understand the first part of it when he characterized what the testimony was.
The objection's hearsay, Judge.
Well, I understand that, but when he characterized what Mr. Mateer's testimony was, I just asked him to repeat what he said there because I just didn't get it. That's all I'm saying.
What I said was that Mr. Bangert has already testified to you and the jury, Your Honor, that he could not hear what Ken Paxton was saying on the other side of that phone call. And so there is no evidence that he adopted anything that Mr. Mateer said. And so they're not his statements, and it still amounts to whatever Jeff Mateer said is still hearsay.
I'm sorry, but you have to go back on the record. That's not my memory of Mr. Mateer's testimony. That's why I wanted to ask him to repeat it. I don't think they talked for 15 minutes with Mr. Mateer not being able to hear him.
I'm going to overrule. Be careful as you move forward.
So this conversation, did Mr. Mateer give any indication he couldn't hear the Attorney General?
It became clear to me by listening to the conversation it was about Nate Paul, and in particular this question about retaining outside counsel.
Objection to hearsay. Judge, may I be heard?
No, wait a minute. We just went through that. He just ruled on this matter.
I've already overruled. Continue.
Go ahead, sir.
It was concerning the hiring of outside counsel to investigate these allegations that Nate Paul had brought to our office.
Can you put a date on it?
The best I can recall, the conference took place maybe a week and a half prior to the end of September.
Was there anything in this conversation, as you heard from the other end, about him being disturbed that Mr. Pendley would not sign the contract?
Objection. The question calls for hearsay. He's asking what Jeff Mateer said on the phone call.
I believe the court's already ruled on this. I'm simply asking him about the conversation.
I've already ruled on this, Counselor.
Judge.
Go ahead, sir.
Mr. Paxton was frustrated that we were not moving forward with the retention of outside counsel.
Objection to speculation. He didn't hear Mr. Paxton on the phone call. His opinion of what Mr. Paxton thought is improper.
The court has just ruled 3 times on this issue.
My objection was different, Your Honor.
Overruled.
Now, at the end of the conversation, during the course of this conversation, were the people for the meeting at Google having to wait till the General Paxton finished trying to get you to approve an investigation by Mr. Cameron?
I know we went right up to the wire. We may have gone a few minutes past it. I don't recall, but it was close, and it might have gone over.
Well, I'm wondering, is at the end of the conversation, did you have any new instructions as to what the two of y'all were to do about Mr. Cameron?
I did not receive any instructions myself.
All right. As a result of that conversation, did you do anything new or express any new concern about the hiring of Mr. Kamek?
I did nothing new. My concern was heightened substantially.
Objection, non-responsive.
Let him finish the answer.
Counselor, he's answering the question that was directed.
Yes, Judge.
Overruled.
Thank you.
My concern based on that occurrence was substantially heightened because we were about to move into a very intense phase of the Google litigation, and the Attorney General's focus was on Nate Paul, not on the Google case.
So at the end of this conversation, who did you understand that the Attorney General wanted an outside counsel to investigate?
The law enforcement action concerning Nate Paul. That would have included the search of his house, his properties. The theory was that there had been an improper warrant obtained, and I believe there were also allegations of a conspiracy by law enforcement.
All right. And did that include investigating federal magistrates? 8 federal magistrates?
Yes.
Did it include investigating individual law enforcement officers in the FBI?
Yes.
Did it include investigating DPS officers?
I believe so. I believe that's correct.
And did you know at that time, were there any members of the Securities Board that were also part of this that he wanted investigated?
I believe Mr. Saban.
And were you aware as to what both the head of your law enforcement division and Mr. Maxwell, because I'm not sure exactly what his title is, were you aware of what their consistent position has been all along on this matter?
Yes.
And in spite of that, was the Attorney General still insisting on going and investigating these people on behalf of Mr. Paul?
Yes.
When you returned to Austin, when was the next time you had any contact or were aware of this particular activity?
I was in a meeting at the governor's office. I believe it was with Mr. Brickman. We had normal meetings scheduled during that time to respond to COVID.
Can you give us a date?
I believe this was September 30th.
All right.
Toward the very end of September. I received a text message telling me to return to the office, that something had happened. My immediate assumption was that something was Nate Paul.
Why?
Because we had been becoming increasingly concerned. We felt as if matters were coming to a head. The Attorney General was insisting that we move forward with outside counsel. We strongly resisted that. We, at that point, had become cognizant of the pattern that had developed over the preceding 9 months. And it was clear to me that hiring outside counsel to undertake this task could only benefit one person.
I'd object to that opinion. It's an improper opinion.
It's his opinion,
That's
Counselor.
totally responsible. I'm sorry. I'm sorry, Your
Sorry.
Honor.
I said it's his opinion, overruled.
Yes, Judge.
Thank you. Now, when you were at the governor's office, had you been aware or made aware yet of a phone call that had been received by any of your other staff the day before involving Mr. Kamek and subpoenas?
If you're referring to a phone call received by Ms. Mays from a banker,
And I'm only asking, were you aware of that call?
The meeting at the governor's office took place on the same day that Ms. Mays received the phone call from the banker. So if that phone call took place on the 29th, that was the day of the meeting.
All right.
Objection, non-responsive to the question.
Counselor, overruled.
Now, when you were at the governor's office, was there somebody else with you from your staff? Was there another member of the Attorney General's office with you?
My recollection was Blake Brickman.
All right. And were y'all on totally unrelated, normal business with the governor's office?
Normal business.
All right. So what did you do when you got that text?
Excused ourselves from the meeting, and we departed and went back to the office, the Attorney General's office.
And what time that day, on the 30th of September, did you return to the AG's office, and where did you go?
We went to the 8th floor and went directly to Mr. Mateer's office. And Mr. Mateer was there, Lacey was there, I believe others were starting to gather.
All right. And now, would you describe the atmosphere in the room? First of all, how many ultimately ended up in the room talking about this matter?
Mr. Maxwell was on vacation, but all the other deputies that were involved as the whistleblowers ultimately were there.
And what was the atmosphere?
Disbelief, shock, extreme concern.
What were you most concerned about? What did you learn that made you most concerned?
We had been following this pattern of Nate Paul and his interests metastasizing throughout the agency over a period of months. It had become clear to me, based on my conversations with the Attorney General, based on the lack of any substantiation for many of the claims that were made, based on the absence of a public interest in taking actions to benefit Nate Paul. Based on all of those concerns,
Counselor, I'm sorry.
I
If
was
you have an
asking
objection,
you.
raise an objection, but just interrupting, not helpful. I didn't hear an objection, and I just heard interruption.
I apologize, Judge, but I'm just intending to object because I believe that what Mr. Bangert is doing on the stand is not responsive to Mr. Hardin's question, and I have to lodge my objection so that he doesn't testify before the jury.
Counsel, I think he wants you sitting so the rest of us can hear you.
I couldn't
so we
see.
can hear you.
Just please sit. We can hear you better.
I'm objecting while Mr. Bangert is speaking because he's testifying to evidence that I believe is not admissible, and he's telling it before the jury. And so I'm lodging my objection before it gets to the jurors so it doesn't affect, inadmissible evidence doesn't come in and affect their judgment in this case. So I don't mean to speak over Mr. Bangert, Your Honor, but I do have to lodge my objection on behalf of Mr. Paxton.
I just did not hear the word objection.
Okay.
And if he objects, witness, stop talking where you are. Do not continue. I overrule the objection, however.
Thank you, Judge.
And the question was, I was asking you what your concerns were and why. And I think you were in the process of setting that out. Let me ask you this. In the course of this conversation, first of all, you, of course, were not here for opening statements, were you?
No.
And you weren't here for the cross-examination of Mr. Mateer.
No.
If someone was contending that you folks were sitting around involving it in a mutiny, what would be your response to the suggestion that you folks were sitting around there cooking up a mutiny against the Attorney General of the state of Texas?
As in we were, that would make no sense to me. We were trying to protect the Attorney General as much as we could.
As a matter of fact, over the last 9 months, what had been your mission in relation to the Attorney General as it related to Mr. Paul?
We had continually, in various ways, warned him about Mr. Paul. We had discussed with him the absence for any substantiated basis for taking actions to benefit Mr. Paul. We had been rebuffed.
During all that time, were you still a supporter of the Attorney General?
Yes.
Did you believe in the things that he was publicly saying that he believed and he wanted to do?
Yes, that's why we were there.
And did you, all that period of time when you were warning him about Nate Paul, what is your testimony in terms of whether or not you still were looking after the best interest of the public, but also the Attorney General?
Senior staff always has to walk that line. And our job, we take an oath to defend the Constitution of the state, but we also are loyal to our principle. And those two things, in almost all cases, are consistent with each other. So our job is both to protect the interest of the public and to serve at the pleasure of the Attorney General.
And when this meeting is held, by the way, I think you said the 30th, and I want to sort of put a couple events in your mind to see whether it's possible that meeting would have been the 29th, for you to let us know whether it's the 29th or 30th. You ultimately called and made an appointment to visit and go to the FBI during this time frame, correct?
Yes.
And you were over at the governor's office. And if the evidence is going to be unrebutted that you and your group went to the FBI on the 30th, when would this meeting, what is your testimony as to when this meeting that you've been describing would have been?
It would have been the day before. It would have been the day before, the 29th.
Okay. So this meeting where you come back over from the governor's office and you all meet together was on the 29th of September?
Yes.
How long by this time, had you been informed of what these subpoenas that had been served by Mr. Kamek were asking for?
Initially, we were aware of a subpoena to a bank requesting records relating to Nate Paul's financial interests. That was the first one that we became aware of. We subsequently became aware of others.
Did you become aware that these subpoenas were actually seeking information through the grand jury, a criminal state grand jury, of Mr. Paul's opponents in his civil litigation?
Yes.
Objection leading. My objection is that the question is leading, Judge.
I'll put it another way, Your Honor, real
Dane,
quickly.
please rephrase.
Were you aware one way or the other, and if so, what were you aware of in terms of whether the subpoenas of Mr. Kamek were being used and drafted to help Mr. Paul in his civil litigation?
Yes, it became, as the subpoenas began to roll in and we became aware of them, reading them, they were consistent with his argument that he wanted to pursue action against both the law enforcement officials who had pursued the subpoenas of his house and his properties, as well as financial interests related to Mitty Foundation and I believe others.
Now, at this time, when this is all happening, what was there sort of a mood of concern? When you talked about shock, why were you shocked? What were you concerned about?
We were unaware, at least I was unaware, that Mr. Kamek had been taking any action on behalf of our office. I was unaware that he had been retained. I was deeply concerned that the name and authority and power of our office had been, in my view, hijacked to serve the interests of an individual against the interest of the broader public.
And the fact that he had invoked the use of a grand jury to try to help Mr. Paul in his investigation, what level of concern and why was that a bother to you?
It was unconscionable in my view. You were using criminal process to pursue the private enemies.
Objection. I'm objecting to improper opinion about the unconscionability of these actions.
I asked why he was concerned.
Overruled.
Thank you. You can pick back up.
Yes, in my view, the criminal process had been harnessed to pursue the business enemies of an individual, Nate Paul, who also happened to be under intensive investigation by law enforcement.
So how did you folks decide? I think it was seven. Was it 7 guys and 1 woman? I mean, so when I'm talking about guys or women or whatever, how did y'all decide? I mean, what kind of considerations did you give as to courses of action you should follow?
I will speak for myself here.
That's all I want you to do.
As a staffer, you have fidelity to the Constitution and fidelity to your principle. Those two things should always align. Unfortunately, over the previous 9 months, they have been drifting further and further apart. One always assumes the best about their principle and attempts to protect that principle's interests, even at your own expense. When I saw that the subpoenas had been issued outside of the normal process of our office to pursue criminal process against private citizens to benefit one individual, it became clear to me that there was nothing more I could do, that the Attorney General was determined to harness the power of our office
And
to fulfill the interests of a single individual against the interest of the state.
And Judge, I would object to that answer. That answer is speculation about his opinion of what the intent was of other parties.
Overruled.
Now, did y'all try to decide what to do in terms of whether you hire outside lawyers yourself? Or what kind of issues were you concerned about as a course of action going forward, you yourself?
We had stepped into the void at that point. There's no roadmap to follow when that happens.
That's sort of like what we're doing here, right?
Yes.
There's no real roadmap except for something 100 years ago and something in the 70s. You were writing on a clean slate, weren't you?
Yes, much against our will, but our hand had been forced.
So what drove you to make the decision to go to law enforcement?
In my view, there was simply nothing more we could do. The course of actions had played themselves out. The Attorney General was determined to follow this course of action in favor of Nate Paul, despite all of our efforts to persuade him otherwise. The power of our office had been fully, at that point, harnessed to advance Nate Paul's interests, and we had lost the ability to, as senior staff, protect our principal.
Mr. Bangert, there's been suggestions repeatedly in this proceeding that why didn't you just go to the Attorney General? Why didn't you go to the Attorney General? Just talk to him. Did you?
Concerns were raised repeatedly and consistently by multiple members of senior staff over a course of several months. There is no question in my mind, based on my personal experience with him, that he was well aware of our objections.
And in fact, after you went to the FBI on the 30th of September, on the 1st of October, did you as a group send a text message to the Attorney General asking to meet with him?
We did.
And before that, had you been aware that he was out of town when all of this happened to begin with?
Yes.
And when I say to begin with, on the period of September the 28th, 29th, do you know where the Attorney General was?
He was on a business trip out of the state. I don't recall which state he was in, but he was out of state.
And on the 29th or 30th, were you? What was the hurry that you experienced about trying to call this to the attention of law enforcement? Were you concerned what Mr. Kamek was still serving subpoenas out there to private people, or what was your concern?
My concern
Leading about Kamek, he's insinuating the answer in the question, Judge.
I asked what his concern was.
Okay.
Overruled.
My concern was we did not know what we did not know. We knew that he had already been serving subpoenas on banks. We were learning of additional subpoenas. In my view, we had lost our ability to speak into the situation as senior staff. We had no ability to end the use of our office to advance private personal interests, improperly using the criminal process. The only way we could deal with that situation was to make a report to the FBI. At least that was our judgment at the time.
Do you happen to recall why you picked the FBI rather than some other agency?
My recollection was that we had a relationship with some agents at the FBI who we trusted and we knew. And also the FBI, in our view, would have jurisdiction over these kinds of matters.
And in addition, DPS at that time was one of the groups, was it not, that Mr. Paul was seeking to investigate?
Yes.
At the end of the day, how long when y'all decided to go to the FBI, how many of you went and how long were the interviews?
7 of us went. We were interviewed together.
All right. And how long do you think the interview?
Multiple hours.
And once that interview was over, I mean, did you go yourself knowing one way or the other what type of crime might or might not be involved?
I did not have the precise... I had a fairly good idea what was happening based on the evidence I had collected, yes.
But did you, one way or the other, as a person not experienced in criminal law, did y'all sit down and decide what statute it was or anything like that?
Objection to improper opinion about what kind of crime this witness believes was committed.
That's fine. I'll withdraw that question.
Sustained.
Thank you, Your Honor. let me ask you this. Did you consider what he had been doing on behalf of Nate Paul an abusive office?
Yes.
Objection to improper opinion. It invades the province of this jury's decision in this case.
Let me put it in.
Sustained.
Let me put it another way.
Counselor, try a little bit better.
Thank you, Your Honor. Did you yourself, when you went to the FBI, have an opinion that drove you to the FBI about what this conduct by the Attorney General did, that the Attorney General was involved in, as to whether or not he was violating the oath of office that you were familiar with and believed he should be following?
Objection to that question. Again, same objection, Judge.
Overruled.
Yes.
And what did you think? Just you personally?
Objection to improper opinion about in relevance to what this witness thought.
Overruled.
I went to the FBI because I believed that the Attorney General.
Just put the microphone up or move forward, but just move up a little bit if you don't mind.
I went to the FBI because I believed, based on my experience over the previous 9 months, that the Attorney General had abandoned his obligation to work on behalf of the interests of the people of Texas to serve the interests of one person, Nate Paul. And that was based on a series of events that occurred over several months.
Objection to non-responsive. He asked his opinion, not what he based it off of.
Sustained.
Now, after you folks went to the FBI, were you all together when you sent an email the next day to the Attorney General wanting to meet with you?
We did.
What was the Attorney General's response?
It was a very odd response.
What was it?
It was a text message saying that he would be happy to meet with us to address any concerns we may have, or something to that effect.
Well, then did he agree to?
No, we did not meet with him.
How did that go? Did you know whether he was able to meet? Can I have the two exhibits? May have just a moment for Stacy. May I have just real quick?
Sure, Counselor, we're at our break time. Do you want to? I don't know how much longer you have with this witness.
I think only 5 or 10 minutes is all I have left with this witness.
Okay, we'll go about another 10 minutes.
Thank you. Stacy, can you, I believe this is in evidence, is it not? We check.
Before we put it up on the screen.
I'm told it is in evidence.
No objection, Judge, to 225.
No.
Continue.
All right. I want you to look at Exhibit 225 and explain to the jury if you can see it clearly on the screen.
Yes, I see the document.
All right. Do you recognize this document in this exchange of text messages?
It's been a while, but I recognize it.
All right. What I'm going to ask you to do, each text message identifies the sender. I'm going to ask you to publish this to the jury and the public, but keeping your voice up. It's a trick because you got to look in there. First of all, if you would, just start out with Mr. Mateer, identify the speaker, and publish this exhibit to the public.
Yes, the text message is dated September 29th, 2020. It begins at 3:02 p.m. The first text message is from Jeff Mateer to a group of us on a group text. Quote, "We have a major problem. The kid has served a subpoena on a bank. Showed up there in person at the bank." Jeff then sends a separate text with someone from World Class. And then he sends...
Did you later discover the person with him
Michael Wynn.
was Michael Wynn, Nate Paul's lawyer?
Yes, Michael Wynn.
So you have him out there serving subpoenas with the lawyer of the person that's asked for the investigation, correct?
That is correct.
Who you know is under federal investigation as you're going along.
That is correct.
Go ahead.
The next text from Jeff. I need you guys to come back.
All right. Then let's go to the next time and so.
Same day, September 29th, 2020, 9:05 p.m. Jeff Mateer writing to the group from Maxwell.
And what does that, do you have any idea what that's referring to? Do you remember?
I believe Maxwell had been communicating with us at that time about the events of the day and had provided his evaluation as to a letter that we had been writing.
And he was actually in Colorado on vacation, was he?
He was
not?
vacationing.
Yeah. All right, go ahead.
Then Jeff pastes in this language, read the letter, not sufficient. A request letter must allege specific allegations that are in violation of state law to include documentation of criminal act. The only thing you have is what happened today that is documented.
And what letter are you talking about there? Or is he talking, that you're talking about? Do you recall?
My recollection is that there was a letter that had begun to be circulated amongst senior staff, but I am reaching into my memory to recall this specific time frame.
Were you at that time drafting a document to be told to be sent to either law enforcement or to the Attorney General announcing? Do you recall? If you don't recall, just tell me you don't remember.
At some point during that date or the next, I was more or less helping scriven. I was a scrivener writing up documents, including allegations concerning what had happened that day. Yes.
All right. Go ahead.
There's a text from someone who is unidentified. It's the person from whose phone this text was produced. It says lots of undue influence. I'm assuming that's Mr. Brickman.
All right. So now read so go ahead.
I then respond, okay, sounds like we need to beef up the specific allegations.
Go ahead.
I then text again. So do we need to lay out the facts that led up to today's events, KP taking NP, that would be Ken Paxton and Nate Paul, to Moore, that would be Margaret Moore, obtaining the referral, demanding that we investigate facially bogus charges, refusing to take our advice that there is no prosecutable offense, demanding that we hire outside counsel, overriding our advice a second time, and apparently now authorizing an improper fishing expedition by private attorneys into a civil matter.
All right, and then you have another one right after that, do you not?
I do.
Go ahead.
I then continue. Or do we need to go further and describe the constant demands that we put the resources of the office at the service of NP's private interest? That's Nate Paul. Personally intervening in open records issues, demanding intervention in a charitable dispute over the objection of staff, demanding an informal opinion to apparently, parentheses, after the fact, benefit Nate Paul. And now, finally seeking criminal investigation of federal officials involved in a criminal investigation of Nate Paul.
Keep on going.
Could you please scroll?
Yeah.
I then send another text. All the while over the objection of staff, its pattern and practice evidence strongly suggestive of an improper motive.
All right, let me stop you there a second. Did you believe at this time that the Attorney General that could enter into contracts, even if all members of his staff objected? Did you have any question about that in your mind?
He is the principal, and I believe he could.
All right. What was your position as to whether either ultimately, however, there might come a time where the Attorney General, in exercising what he believed he had the legal authority to do, could do something that became illegal by being used for an improper purpose? Did you have an opinion on that?
I did.
And what was it?
Yes, the Attorney General could use the lawful powers and authorities of our office for a patently improper purpose, such as using the power of our office to benefit the interests of one individual citizen at the expense of the public interest, that is improper.
If, in fact, you reach a conclusion that that has repeatedly been done, in spite of consistent advice against it by the staff, what is your opinion where there ever comes a time that staff has to complain and say, enough is enough? You can't.
Objection to improper opinion.
All right.
I'm sorry, overruled. He has the opportunity to offer his opinion.
Yes, Judge.
Yes, and that is precisely what we did.
Did you consider it a mutiny?
It was not a mutiny.
How would you characterize it?
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
What was the stated awareness of all of you that knew the consequences of what you were doing when you staked out this position and decided to go to law enforcement?
We understood the gravity of that act. We were fully cognizant of it. It was something that we did not want to do. It was something that we tried earnestly to avoid ever having happen. But when the moment came and we realized there was no other choice, that is the duty of a public employee, to ultimately make that incredibly hard choice to serve the public interest, even at the expense of your principal, because he has insisted on an improper and, we believed, unlawful course of conduct.
Mr. Bangert, did every single one of you pay an extreme price for what you did?
Objection to improper opinion. It invades the province of the jury with regard to an article.
Sustain. Rephrase.
Bangert, what happened with you? How did you end your employment with the Attorney General's office?
I resigned from my position immediately after the 2020 election. By the time I resigned, all of my duties had been taken from me. I was simply an employee in name only.
When you, after you went to law enforcement, how do you mean your duties were taken from you?
Over the course of several weeks, I was excluded from and ultimately removed from any responsibility by the new first assistant. And then subsequent to that, in the middle of October, I was informed that I would no longer be overseeing the special litigation unit. I objected to that, and that was to no avail.
Counselor, you said about 10 minutes were for the benefit of the jury and the staff. Do we want to break here, or do you need a
That's
few more
fine.
minutes?
I want to have a few minutes, but that's fine. That's
If you
fine.
want to if you have a few minutes, finish with the witness. If you're going to go longer, then tell me and we'll break.
Thank you so much. I never want to be in the way of people taking a restroom break.
All right.
Thank you.
We will break until 11 o'clock sharp. That's a 20-minute break, members. Court will come to order. Mr. Harden, you can continue.
Thank you very much, Your Honor. Stella, can I have hard copy exhibits for the court and the other side on Exhibit 571? And can you give the witness one so that it doesn't have to be put up on the screen?
Is this already in evidence?
It is not. That's what I'm going to seek to introduce. Thank you, Your Honor. So now, without going in to specific contents, do you recognize this exhibit?
Yes.
And without talking about the contents as to what it says, how would you identify it in terms of what it is?
This is a text message that was sent
Microphone, I'm sorry.
This is a text message that was sent by the group of us to the Attorney General.
All right. And does it also contain the Attorney General's response?
Yes.
Are you aware of people, of any instance where there's been criticism that you did not seek to meet with the Attorney General? Are you aware that there's been that criticism?
I'm aware of that, yes.
All right. Now, Your Honor, we move to introduce 571, the understanding this witness participated in sending this along with the other group of people we've been talking to as the whistleblowers.
Any objection?
No objection, Judge.
Continue.
All right, can I have it up on the
submit it to
screen,
evidence.
please? The first page, would you show who all is, would you, for the record, explain who all it says is sending this?
The beginning at the top of the
Yes.
page,
Yes.
Lacey Mays, Deputy for Administration, is sending this email, which contains a screenshot, to Jeff Mateer, Blake Brickman, Ryan Vassar, Ryan Bangert, myself, Mark Penley, and Darren McCarty.
All right, if you would look at the screenshot on that first page, and we turn, does this exhibit contain a screenshot of the text messages that you as a group, the addressees up at the top, sent to the Attorney General?
Yes.
And did you send it on what date, if you would look up there?
The date is not listed, but this would have been
The screenshot is dated, is it not?
the
Can you see it?
screenshot.
Yeah, the first page.
Yes, this is the email is dated October 1st.
Right. The email has been sent around, but if you look at the second page of this exhibit, does it contain correspondence with where each of you give it? Let me back up. Strike that. And I apologize, Mary, ma'am. If you just give the jury the background of why y'all sent this and when you sent it.
Yes. We sent this message to the Attorney General after we had made a good faith report to the FBI. We wanted to speak with him. We wanted to bring him back to the office. So we wanted to invite him back to the office to speak with us so that we could address these concerns head on. We were hoping that we could finally resolve these issues and, in our view, end this unlawful use of our office's resources.
All right. Now, the screenshot was dated October 1st, and in fact, your group went to the FBI, I believe you testified, on September the 30th, correct?
That's right.
This email that Jeff Mateer sent on behalf of all of you, would you read that out loud, published to the jury, please?
The text message?
Yes.
Yes. Jeff Mateer at 12:49 p.m. General Paxton, yesterday, each of the individuals on this text chain made a good faith report of violations of law.
Nice and slow.
I'll begin again. General Paxton, yesterday, each of the individuals on this text chain made a good faith report of violations of law by you to an appropriate law enforcement authority concerning your relationship and activities with Nate Paul. We request that you meet with us today in the 8th floor conference room at 3:00 p.m. to discuss this matter.
Now, at that time, since when it says yesterday here, and I believe you testified that the two of you went to the FBI on the 30th, correct?
The group of us did.
Yes. And then on the 1st, you send this text. So when we see on there today, 12:49 p.m., this message from Mr. Mateer on behalf of all of you would have been sent on what day?
The following day, the 1st.
October the 1st. And at that time, did you know whether or not the Attorney General was back in Austin from his trip out of town?
Yes, my recollection is that he had returned late the previous evening.
Late the evening of the 30th?
Yes, that's my recollection.
Okay. Would you publish to the jury what he responded to you about 3 hours after you sent it?
Yes, at 3:08 p.m., Jeff, I am out of the office and received this text on very short notice. I am happy, as always, to address any issues or concerns. Please email me with those issues so that they can be fully addressed.
And so did you email him with those issues?
I don't believe we did. I don't recall. We wanted to meet with him personally.
And if you did not, why would you not have?
He was well aware.
And how did you take that, asking for the issues?
I interpreted that message as he was not going to engage with us on this.
Did he ever reach out to and try to?
No, not to me.
And as a former deputy first assistant, you remain still with the office, available to talk to him for how long?
I remained with the office until after the 2020 election in November, early November.
At any time after you sent that text, did the Attorney General ever attempt to discuss any of these issues with you?
One time.
When was that?
I had turned in my notice of resignation. I was in the process of gathering up the things in my office, and I was alone in my office, and he walked into the office unannounced and closed the door behind him and was pacing to and fro in the office. He was very agitated, in my view. And he said to me, "Ryan, I just want you to know that you're only sitting in this office today because of me."
What else did he say?
He said, "This was not Jeff Mateer who put you here, it was me."
He said what?
He said, "Jeff Mateer didn't put you in this office. It was not his decision, it was my decision. I put you here."
Okay.
And it was a very odd conversation. I wasn't quite sure how to respond, so I just told the Attorney General that it was my hope that God would work things out in the end. That was the only time that he spoke to me alone about these issues, and that was it.
What is your observation as to whether in encounters of unpleasant or difficult issues, the Attorney General's characteristic is as to how he acts in issues of conflict, or whether he avoids them?
Objection to relevance.
Sustained.
After you left, Could you describe for the jury the impact of all this has been on you?
Yes, that month was a very unsettling month. I was waiting to be terminated. Instead, I just had my job duties stripped from me and was left more or less a man without portfolio in the office. I watched as my fellow whistleblowers were placed under administrative leave and investigated. I watched as certain members of the staff, the new staff, treated them in a belligerent manner, including myself, and ultimately I resigned. It was incredibly heartbreaking because I had believed in Ken Paxton and what he had been doing for years. I'd moved my family here to Austin specifically to go to work for him. And I watched all of these things that we had done as a leadership team slowly begin to unravel. And it was absolutely heartbreaking to see that happen to an office that had been, in my view, a beacon for the conservative legal movement for years.
Have you noticed he's not even here today?
Objection to relevance.
That's very relevant. I want the record
Objection
to
to
reflect.
relevance.
If I could, I'll ask that question again.
Sustained.
All right. I want the record to reflect that Attorney General Paxton was not here entirely. I'm just making this for the record. I think we're entitled to point out.
I'm objecting to the attorney
That,
testifying.
excuse me, let me finish, please.
Quit talking over each other. Court reporters cannot record. I sustain his objection.
Yes, sir, I understand, and I'm not any longer trying to ask that question. I do want the record to reflect that neither yesterday nor today has the Attorney General graced us with his appearance. That's all. I wanted to make that statement, please, for the record. I thank you very much, Your Honor. I'll pass the witness.
Judge, may I have a moment to just prepare my exhibits up on the bench or the
Yes.
podium? May I proceed, Judge?
You may proceed.
Mr. Banger, we heard a lot about your background. Obviously, you have a very esteemed career and resume, correct?
My resume is what it is.
Okay. Mine's not like yours, and so I'm just going to try and do a courtesy to you and ask you short and simple questions, okay? And I'd ask that if I ask you a yes or no question, that you simply respond yes or no, all right?
Understand.
Okay. Now, you are currently represented by an attorney, correct?
I am.
Okay. That attorney is Johnny Sutton.
Yes.
That is the same attorney that represents Jeff Mateer, correct?
It is my understanding that he also represents Jeff Mateer.
Okay,
Yes.
So you and Jeff Mateer both have the same attorney.
We do.
Okay. As a matter of fact, Mr. Sutton is here today in the building, right?
Yes.
He's probably watching your testimony.
I assume so.
Okay. And as a matter of fact, the two of you were just in the restroom together about 15 minutes ago?
You would know that because you were there too.
I know, right? But that's a yes, correct?
That is a yes.
Okay. So you guys have been in contact during your testimony in this trial.
We have.
All right. Now, you stated on direct examination that you did not provide any statements with regard to what you've testified in court today, right?
Could you please reframe? I don't understand the question.
Sure. And I think the record reflects when Mr. Harden asked if you made any statements in this case, and when Judge clarified if you had made any statements before this testimony, you said that you hadn't.
I do not recall testifying to that effect.
Okay. So you've made statements previous to your testimony today, right?
Again, when you say statements, have I spoken to anyone?
I mean, you have made an out-of-court statement, Mr. Bangert.
Are you talking about under oath?
I'm asking you yes or no, have you made statements about this case to anyone?
You may answer the question. What's your objection?
My objection, Your Honor, is if he would just please express what he means by statements. That has a legal significance and a practical one.
Overruled.
This witness is not aware of the issue.
Overruled. Answer
Yes.
the question.
So
It's a yes or no question.
it's not a yes or no question.
Well, then
sir.
let me ask you a more specific question. Were you interviewed by the House Board of Managers in their preparation investigation of this case?
Yes, I was.
Okay. Were you interviewed by Mr. Hardin and Mr. DeGuerin prior to your testimony for this case?
Prior to my testimony today?
Yes.
I was, yes.
Okay. So those are two statements that you've made to people about your testimony in this case, right?
I'm not trying to fight with you, counsel. I'm simply pointing out that the word statement carries legal significance, typically under oath.
Well, hearsay is
Those are
any
not
out of-
under oath.
Yes.
Witness,
Yes, ma'am.
answer the question. Not argue with the counsel.
You've made two interviews prior to testifying today, right?
I have given interviews, yes.
Okay. Two of them.
I have spoken both with the House Managers Council and I've spoken with Mr. Hardin and Mr. DeGuerin.
Yes or no, Mr. Banger? Were either of those interviews recorded?
No.
Did you ask that those interviews not be recorded?
No.
Did your lawyer ask that those interviews not be recorded?
Not to my recollection, no.
So you don't know why they were recorded? Why they were not recorded?
I do not.
Okay. If Mr. Hardin or Mr. DeGuerin had had any objection to you being recorded during your interviews, would that have been a problem, yes or no?
I don't understand the import of the question. Would that have been a problem for me?
My question is, if Mr. Hardin or Mr. DeGuerin had said, Mr. Banger, you're giving an interview with regard to testimony in an impeachment trial, can we record you? Would that have been a problem for you or Mr. Sutton?
I can speak for myself. I would have no problem with that.
Okay. And despite your lack of objection to that, Mr. Hardin and Mr. DeGuerin chose not to interview you during your interviews with regard to this case?
Chose not to record me.
Yes.
I assume that was their choice, but I was not recorded.
Okay. And additionally, prior to that interview, when you met with the House Board of Managers, safe to say you wouldn't have had an objection to them recording you either, correct?
I can't think of any at the time, no.
Okay. And it just so happens that the House Board of Managers, the investigators in this case, chose not to record your statement either.
As far as I know, they did not.
Okay. So you would have to agree that there are a lot of things that you testified to when Mr. Hardin was directing you that we were hearing for the first time on this side of the trial, correct?
I honestly cannot answer that question. I do not know what you know and what you do not know.
Okay. Well, you had information that you produced actually to both sides of this trial within the last 2 days, correct?
There was a text chain that was produced by my counsel.
Okay. We didn't see Mr. Hardin produce those text messages during his direct, did we?
Mr. Hardin producing his text messages to whom?
During his direct examination of you, he did not ask you about text messages that you produced yesterday during this trial. Yes or no?
No, he did not.
Okay. Your Honor, may I approach the witness?
Yes. Don't speak to him now. Just give it to him and then speak from the microphone. Thank you, Counselor.
I'm handing you.
Hold on. Everyone wants to hear you.
I'm handing you what has been pre-marked as Attorney General's Exhibit 1000 and I believe 3, correct?
It is marked AG 1003, yes.
Okay. Now, you recognize this document, do you not?
I do.
These are text messages from your cell phone, right?
Yes.
You produced these to both sides in court yesterday.
Mr. Sutton, my attorney, produced them yesterday.
Okay. And you would agree that these are a fair and accurate...
Counselor, excuse me, we do not have a copy of
Yes,
what you
Judge.
have. Continue.
Yes, Judge. You would agree that these are a fair and
Your
accurate
Honor,
reflection...
pardon me, Your Honor, we were not given a copy of those. Could we have a copy of them, please?
They gave it to us, so whatever.
Thank you.
I'd ask the record reflect that I have tendered to opposing counsel a copy of their witnesses' text messages.
Let the record reflect.
Now, Mr. Banger, you would agree that these are a fair and accurate reflection of the text messages between you and Ken Paxton in July and August of 2020, correct?
Give me a moment. With the only modification that the first text message is in June.
Okay. Well,
It goes through
your
August.
attorney produced these, so presumably he got them from you, right?
Yes.
Okay. Otherwise, fair and accurate reflection?
Yes, they appear to be.
Judge, at this time, I would move to admit AG Exhibit 1003.
Any objection?
No objection, Your Honor.
Show the exhibit being entered into the record.
Okay.
Admitted to evidence, excuse me.
Thank you, Judge. Mr. Banger, you talked about two very, very, very specific conversations that you had with Mr. Paxton that I think stood out during your testimony. The first one of those was a conversation at Polvo's, correct?
We did, well, Nate Paul was part of that, but
Right.
we were at Polvo's at lunch together with Mr. Paxton, Drew Wicker, and Nate Paul.
And the second conversation was essentially a conversation that you overheard Jeff Mateer was having, right?
The conversation at the Raga meeting in Atlanta, yes.
Okay. Two separate conversations.
Yes.
Did you provide, I don't recall, did you provide dates of those, specific dates of those conversations during your direct examination?
I do not believe I did.
Okay. Now, you talked a lot about your experience and your resume. I think you've clerked, you've worked at, was it Baker Botts as a partner, right?
I have both clerked and worked at Baker Botts as a partner, yes.
You've worked at executive level positions in 2 attorney general's offices?
Yes.
You didn't get there because you don't have an attention to detail, right, Mr. Banger?
I'd like to think that I pay sufficient attention to detail.
Right, and you document things that are important to you, do you not?
Not always.
Not always? Okay. Well, let's talk about that. You had documented in this case something that you thought was very important, the foreclosure opinion, did you not?
I made a document that outlined my concerns about, oh, sorry, you said the foreclosure letter?
Yes, the foreclosure letter.
Well, I was shown the foreclosure letter today, yes.
At this time, I would ask Eric if you could publish the House Board of Managers Exhibit 119. Mr. Banger, this is an email that you sent to Ryan Vassar on September 30th.
Counselor, excuse me, has this been entered into evidence?
My understanding is it has. If not, Judge, I'll ask to enter. It's the House Board of Managers exhibit. At this time, I would offer.
We do not object, Your Honor.
Okay. Admitted into evidence.
Thank you, Judge. Now, Mr. Banger, this is an email that you wrote to Ryan Vassar on September 30th of 2020. True?
Yes.
September 30th of 2020 is after you had the meeting with the other executives about going to the FBI with regard to Ken Paxton. True?
This is at 9:29 a.m. that morning. We had not visited the FBI at that point.
Okay. It's the same day that you had a conversation with the other executive level AGs about going to the FBI, right?
We did on that day.
Okay. And September 29th, or excuse me, September 30th, that's 2 months after you ever drafted the foreclosure opinion that you talked about during your direct examination, correct?
Slightly under, but about 2 months later, yes.
Do you typically write memorandums about things that happened 2 months ago? Yes or no?
No.
Does it stand out to you, or does it seem odd to you to wait until the day that you go to the FBI or the day before you go to the FBI to write a memorandum about something that happened 2 months ago?
No.
Not odd at all?
No.
Okay. Now, to be clear, yesterday during Mr. Hardin's testimony, he at one point said, I think by the end of July, beginning of August, you had been a part of 3 issues that related to Nate Paul, right?
Well, depending upon how you count the open records issues as one or two.
Okay. Well, you have the open records issue, correct?
Yes.
Your involvement in MIDI.
I was involved in MIDI as well, yes.
Okay. And then you've got your foreclosure opinion involvement.
Yes, that is correct. I was involved in all.
And as a matter of fact, a lot of those almost overlapped each other, true?
At the edges and at the margins, they did overlap.
Okay. Now, yesterday you testified to the jury that you had a boiling concern about this, correct?
I did have boiling concern about this.
Now, to be clear, House Boards 119, your email to Ryan Vassar, is the only memorandum and summary that you drafted with regard to any of your involvement with MIDI, open records request, or the foreclosure opinion. Yes or no?
I can't recall.
You can't recall. Okay. Well, we didn't see any other memorandums, have we?
I haven't seen any in the trial today.
Okay. Well, you would have produced it, so you'd know about it, wouldn't you?
I produced everything I had.
Okay. And all we got was this email.
I produced far more than this email.
Okay. Now, I want to backtrack a little bit, and we'll go back to that correspondence between you and Mr. Vassar. You talked a little bit about the time from when you guys came out to the FBI and what happened to you after, okay? I want to talk about that. Eric, would you mind pulling up Article 6 of the Articles of Impeachment? Article 6 accuses Mr. Paxton essentially of terminating or taking adverse personal action against employees for making a good faith report to law enforcement. Would you agree with that, Mr. Bangert?
It says he violated his duties of his office by terminating and taking adverse personnel action against employees of his office in violation of the state's whistleblower law.
Okay. So kind of what I just said, right?
I defer to the document.
Okay. Well, if we read from it, it talks about terminating or taking adverse personal action. So I would like to talk about what happened to you. Now, at no point after you reported to law enforcement were you terminated from your position. It's a yes or no question, Mr. Bangert. Were you fired or were you not fired?
I was constructively discharged.
Now, I asked you whether you were fired or not fired, yes or no.
Answer the question.
I was constructively discharged.
Did Ken Paxton say you are no longer an employee of the Office of Attorney General?
He did not say that.
Okay, thank you. As a matter of fact, you resigned from the Office of Attorney General as the Deputy First Assistant Attorney General, did you not?
I did resign.
Okay, and you resigned under the title Deputy First Assistant Attorney General.
That was my title at the time I resigned.
Okay, so you were not demoted from your position as First Assistant Attorney General.
I did not lose my title.
Okay. And as a matter of fact, you were never suspended after you reported to the FBI, were you?
I was not.
Okay. You talked about Mr., I think maybe Webster, but certainly Ken Paxton stripping you of some of your responsibilities, right?
Yes.
One of those responsibilities was the fact that you were in charge of the Special Litigation Division, true?
I was.
Now, that role was actually moved out from underneath you, correct?
That is correct.
And they put it in charge of the division chief that was running that division at the time, right?
My understanding was that Patrick Sweeten was put in charge of that division, yes.
So essentially, Brent Webster promoted an under-level assistant attorney general? Yes or no?
I do not know if he promoted Patrick or not.
He certainly added some responsibility for Patrick, correct?
That was my impression, yes.
And that bothered you? Yes or no?
It came without explanation or warning, so yes, it was troubling to me.
It's possible that Mr. Webster just was promoting somebody that had been, I don't know, giving an exceptional performance at their job.
That was the excuse that he attempted to give me.
That's not what I asked you. I asked you if it was possible.
I don't think so.
Okay. Certainly they wouldn't take a job from Ryan Bangert, right?
That's not exactly what I said.
Okay. Sounded like it. You said that the environment, did you describe it as being hostile after you reported to the FBI?
Yes,
Maybe
it was.
Toxic, right?
It was.
Affecting the ability for people to get their work done?
It was.
Okay. Now, you left and you went to work for the Alliance Defending Freedom, didn't you?
I did.
And in your time, well, that would have been 2020, true?
Say again?
When you left the Office of Attorney General and you went to Alliance Defending Freedom.
Counselor, can you raise that mic up a little bit closer
Sure.
to you? Okay.
Is that better, Judge?
That's much better for
Okay, I'm gonna
all
lean
the
in here.
jurors.
Yes.
When you left the Office of Attorney General and went to Alliance Defending Freedom, that was in October, November of 2020.
November of 2020.
November of 2020. And since your time in November 2020, all the way up until, I believe, 2023, isn't it true that you have brought cases from the Alliance Defending Freedom to be co-handled with the Office of Attorney General?
We have.
Okay. And some of those cases you have worked directly with Brent Webster, have you not?
There have been some, yes.
Specifically, State of Texas versus Xavier Becerra.
I believe that's the title of the case in Lubbock, Texas.
Okay. And that was one of a few cases, true?
Yes.
And all the while that you were bringing cases from Alliance Defending Freedom back to the Office of Attorney General, Brent Webster was acting as first assistant, true?
That is my understanding.
Okay.
Yes.
And Ken Paxton was acting as Attorney General.
Yes.
I want to talk to you about the open records request, okay? You kind of gave us an explanation of how the process works, so I just want to rehash that out. My understanding is that if an individual makes a request to a state agency, that state agency has a certain time period to go to the Office of Attorney General and make a request for a ruling, right?
There is a statutory time period to request a ruling, yes.
Right. So in this case, the statutory time period, well, for example, when Nate Paul went to the Department of Public Services in March of 2020, if that was March 3rd, they had till March 13th essentially to request your office give an opinion. True?
I do not recall the specific dates, nor do I recall whether it was Nate Paul or one of his attorneys who made that request.
Okay. I just want to clarify, you do not recall the specific dates in which the DPS request by Nate Paul's attorney was made?
It was in the spring of 2020, but I don't recall the precise dates. I'd have to see some documents around that.
Eric, would you mind pulling up Article 3? And while we're doing that, just for a little background, Mr. Bangert, the requests by Nate Paul's attorneys for the records involved in the investigation, it was for initially the Texas State Securities Board, right?
Yes, the initial request went to SSB.
That was in 2019.
Is that a question?
Yeah, that was
Yes,
in 2019.
Yes, it was.
Then you've got DPS. That request was made in the spring of 2020.
That is correct.
And sometime later, arguably end of May, there was a request made for FBI's comment or brief on the DPS request that was originally filed in the spring, right?
I believe that was part of the second request.
Okay, so we're talking about 3 different records requests, correct?
I would classify it as 2 with a secondary request attached to the second.
Okay. And then you also have to throw in the request for reconsideration, right, on the Texas State Securities Board.
That was part of the first file.
So essentially, the Office of Attorney General makes 4 separate decisions about records relating to Nate Paul.
We made at least 3. I don't know if it was 4.
Okay. Well, let's go back to fall of 2019. Texas State Securities Board. At that time, was Ken Paxton the office of he was the AG of the Attorney General's office, right?
Yes, he was.
Now, when Nate Paul made that request through Aaron Borden, his attorney, in fall of 2019, that initial request was denied by the Office of Attorney General, was it not?
Yes, the ORD did, well, when you say denied, it sustained the request for exemptions and exceptions by the board.
Sure, meaning that the Texas State Securities Board, while Ken Paxton was AG, was not required to turn over records to Nate Paul.
That's right, the November request did not require turnover of records.
Let's move forward to 2020. You had a conversation with Justin Gordon about a request for reconsideration of the Texas State Security Board records, true?
I did.
And ultimately, you ended up having conversations with Ken Paxton about that request for reconsideration.
I did.
And ultimately, the Office of Attorney General again did not rule that the Texas State Board, the Texas State Securities Board was going to have to turn their records over to Nate Paul, did they?
We did not require them to turn their records over.
Okay. So up until, that puts us in February or March of 2020, would you agree?
We're ballpark in that area, yes.
Right, ballparking it because yesterday you stated it was right around the time COVID started.
Yes.
That's a whole nother convo we'll get into in a little bit. Okay, so Texas State Securities Board records are not given to Nate Paul. Let's move on to DPS. Now, to be clear, the ultimate decision by the Office of Attorney General with regard to the DPS records was that they refused to rule in that situation.
It was a no decision.
Okay. Now, I want to talk to you about what that means. If the Office of Attorney General refuses to rule on a records request, that means that the state agency that was requested does not have to turn their records over to the individual, right?
We did not require disclosure based on that ruling.
Okay. And so, as a result of that ruling, the Department of Public Safety did not turn their records over to Nate Paul or his attorneys, true?
That ruling did not require disclosure.
Okay. Well, you're aware that there was a writ of mandamus filed by Nate Paul's attorney for those records they were trying to get from you, correct?
You're going to have to, the writ of mandamus, I believe, occurred with respect to the initial request. I don't recall one on the second request, but it may have happened.
You would agree there was a writ of mandamus filed?
At some point, it was my understanding that a writ had been filed.
Okay, and you're not going to tell this jury when that suit was resolved, are you?
No.
For a matter of fact, it could have been pending into the winter of the next year, true?
As far as I know, and for clarity, when you say a writ of mandamus, I'm assuming you're talking about federal practice.
No, I'm talking
the Fifth
about
Circuit.
no writ of mandamus in the district court for the Department of Public Safety records.
You're talking about the second issue then. Okay.
Yeah.
No, yeah, there was a pending action in the district court.
Okay, so they weren't just going to Office of Attorney General to try and get these records that they were after, right?
Could you repeat one more time?
They weren't just going to the Office of Attorney General, Nate Paul and his lawyers. They were also going to the district court to try and get the records they were after, correct?
That was my understanding.
Okay. Now, DPS was not required to disclose records after this refusal to rule, right?
Our refusal to rule did not require them to disclose.
You stated that that was contrary to precedent at the Attorney General's office, true?
I did.
But you would have to admit that this specific request made by Nate Paul and his attorney Joe Larson had some unique circumstances, true?
I don't recall any unique circumstances.
Well, you worked with Justin Gordon pretty closely on this case, didn't you?
I worked with him very closely on the first file for SSB and somewhat, but less closely on the second file.
Okay. Could you kind of, so you really delegated it to Justin Gordon to handle, right?
No.
He was the man in charge of this decision, was he not?
He was the head of open records, answering to Ryan Vassar, the deputy for legal counsel at the time.
And he drafted opinions, and he drafted the opinion to refuse to rule that you edited, true?
I did edit the opinion.
Okay. Your Honor, may I approach the witness?
Yes, you may. Just don't talk on your way up or back.
Yes, Judge. I guess the point I'm getting at, Mr. Bangert, is that not every, like you said yesterday, you said that pretty much all of these requests are kind of the same. They're easy to rule on when it comes to law enforcement material, true?
They're not all easy, but we get a lot of them.
Right. You referenced the opinion, the law enforcement exception, true?
Yes, I believe that's correct.
That doesn't
When you say
necessarily...
the opinion, which one are you referring to, though? I want to make sure I'm answering accurately.
Well, the DPS opinion
I believe that's correct. I need to see it again.
and the FBI comment.
Again, I need to see the document.
To be clear, there was an initial request for DPS records in spring of 2020, true?
That is my understanding, yes.
Okay. There was a later, you're aware that DPS did not notify the FBI about the records, true?
I don't recall that. You'd have to refresh my memory on it.
So it sounds like you don't know every little detail about the records request, do you?
No, and that's perfectly normal for a senior executive
Okay.
not to know every detail.
So yesterday when you said that the decision was not consistent with precedent, you didn't know every little fact about what was going on within this request, did you?
I knew enough to make that determination.
Well, you didn't know everything, did you, Mr. Bangert?
I am not omniscient, so no, I did not know everything, but I knew enough to make that determination.
And it's fair that maybe Mr. Gordon had a different opinion about what went on with regard to those records requests.
Mr. Gordon was working on that. I do not recall what his opinion was.
Okay. Are you aware that ultimately the Office of Attorney General did disclose the FBI comment?
I do not recall that.
Okay. Are you familiar with June Haddon?
June Haddon, the name is familiar. I believe she worked in the Open Records Division.
Okay. Would it surprise you to find out that she ruled that the FBI's brief on the DPS record should be disclosed to Nate Paul and his attorneys?
I'm not aware of that, but I'd have to see the ruling.
Okay. You hadn't heard her name with regard to this litigation or case today, have you?
No, not until today.
Okay. And you have no opinion as to whether Ken Paxton prodded June Haddon to turn those records over to Nate Paul, do you?
You'll have to ask the question again. It was coming fast.
There's no evidence, you don't know of any evidence, or you have no opinion that Ken Paxton told June Haddon to turn the FBI comment over.
I'm not aware of any conversation to that effect.
Safe to say that in conclusion, every single request for records from Nate Paul's lawyers, none of those resulted in him getting the records with regard to DPS and Texas State Securities Boards, right?
I'm not aware of any disclosures that were made,
Okay.
at least by our office formally.
So essentially every ruling that was made with regard to those records was the same, had the same effect as if you refused to require DPS or Texas State Securities Boards to turn those records over.
The net result was they did not have to disclose the documents.
Okay. You were involved with Biddy as well, right?
Yes.
Now, you talked about the fact that Ken Paxton directly ordered you to intervene into the lawsuit, true?
Yes.
Now, you would agree that if you thought something was illegal, you wouldn't want to delegate it to a lower level attorney, true?
That I don't even know how, no, that does not.
Yes or no? Would you delegate illegal activity to a lower ranking attorney?
The question doesn't make sense because I wouldn't carry out illegal activity.
Judge, I'd asked a non-responsive. I've asked him a question.
Answer the question.
Yes or no?
I would not instruct anyone to carry out illegal activity.
Right. That's why you didn't have Ryan Vassar sign that opinion in July of 2020.
I did not have him sign that opinion because I had a very bad feeling of where that was headed.
Okay. Well, let's talk about what you did in the Biddy case. You had no problem instructing, well, let me rephrase that. You did instruct Josh Godby to intervene into the Biddy case, did you not?
I did.
And when Ken Paxton asked you to file a motion to stay, you told the jury that you were opposed to filing that motion to stay, did you not?
I did.
But you turned around and you asked Joshua Godby to file a motion to stay in that case, did you not?
I don't recall that.
Okay. He filed a motion to stay, didn't he?
That is my understanding. Eventually, a motion to stay was filed.
Okay. You didn't walk up to Ken Paxton and say, Ken, I don't agree with what you're doing, and so I'm not going to do it.
I did not have that conversation with him, no.
And at no point did Ken Paxton say to you that if you do not intervene into the Mitty case, that you're going to be fired.
No, we never had that conversation.
You are aware that Mitty has been previously of interest to the Office of Attorney General, true?
You'll have to refresh my recollection.
Okay. Well, when Greg Abbott was the Attorney General, you're aware that the Office of Attorney General filed suit against Mitty.
Yes, that did happen.
Okay. So you are aware that their background isn't necessarily squeaky clean.
I wouldn't put it that way.
Okay. You would not tell, you got no knowledge that Ken Paxton was entering into the Mitty litigation for the purposes of benefiting Nate Paul, would you?
Well, I disagree with that.
Okay. Do you have personal knowledge? Yes or no?
I do.
You do?
Yes.
Well, Jeff Mateer made you aware of the fact that Jeff Mateer made you aware that World Class was disgruntled and not happy with Joshua Godby's performance in the intervention in Mitty. True?
That was some time later, but I received an email. I was copied on an email in which Jeff responded to current counsel for World Class, complaining about Joshua Godby.
Okay. So World Class was complaining about Joshua Godby. True?
They were.
Okay. Now, at some point, you stopped talking to Joshua Godby. I want to say that was, excuse me, let me back up. You stopped talking to Justin Gordon about the open records request. True?
At some point, the issue came to a rest,
Right,
so I would have no occasion to talk to him after.
Probably when you made the final ruling not to disclose the records in the Department of Public Safety request.
When the no decision was issued, yes, that's when it would have terminated.
Now, about 1 or 2 days after that, it might have been June 2nd, you started talking to Joshua Godby about the Mitty Foundation case. True?
That sounds about right, yes.
And Ryan Vassar has his hands in the open records request at that time
Seeing the Open Records Division.
because he took your position, right?
He did when I was promoted.
Okay. So Ryan Vassar is also probably aware of these different interactions with Nate Paul between the Office of Attorney General and Nate Paul, correct?
You'll have to ask him that question.
Okay. Well, safe to say that he worked on the open records request with you, right?
He worked on it, yes,
And he worked on the foreclosure opinion with you, true?
he did.
Okay, so those are two different scenarios where you and him both worked on Nate Paul issues, true?
At least those two.
Okay, and it's fair to say that you and Mr. Vassar were discussing the fact that you both had been involved with Nate Paul
At what time?
at some point when you were working on these cases.
We had discussion around those two instances. We discussed the work that we were doing.
Okay, so you would not tell our jury, the senators, that the executive level attorney generals did not know that different divisions or facets of the office were involved with or working on cases regarding Nate Paul, would you?
We began to piece together the linkages between these matters over time.
Okay. But you didn't do anything about it until September, I want to say 30th of 2020, true?
That's false.
Well, you didn't go to the FBI until September 30th of 2020?
We didn't go to the FBI.
Let's talk about that foreclosure guidance. Eric, would you mind pulling up Article 2? And to be clear, Ken Paxton is allowed to intervene into a lawsuit if he thinks it's appropriate, true?
Our office has authority to intervene.
Okay. And he's in charge of the office, is he not?
He is the elected Attorney General.
Okay. So if he wants to intervene in a lawsuit, he is allowed to do so.
He has authority to do so.
Okay. Looking at Article 2, it alleges that Mr. Paxton misused his power to issue written legal opinions under Subchapter C, Chapter 402 of the Texas Government Code. You're aware of this, right?
Yes, I see the article on my screen, yes.
Okay. Now, we actually looked at a copy of that exhibit. Eric, would you mind entering exhibit 192, AG 192? And Judge, for the record, I believe it is an exact copy of a House Board Manager exhibit that they've already published. Would you scroll to the second page, Eric? And just to be clear, Mr. Banger, when we talk about that very last paragraph, you actually signed this opinion, right?
Yes,
Okay. And by signing it, you would agree that you have adopted the statements within it, true?
not necessarily,
Okay. So you just sign things at will?
no.
No? Okay. And you signed this document, right?
I did sign this
And
document.
the very last sentence or paragraph in that document says, it is not a formal opinion under subchapter C of chapter 402 of the Texas Government Code, true?
Would you scroll down to the last paragraph?
Well, you wrote the opinion and you read it a minute ago. You would
I'd
agree
like to
with
see
that.
I'd like to see the document.
I think I've got a copy.
Ah, there it is.
Got it. You wrote, we trust this letter provides you with the advice you were seeking. Please note this letter is not a formal Attorney General opinion under section 402.042 of the Texas Government Code. Rather, it is intended only to convey informal legal guidance.
Yes.
You wrote that, right?
I did.
That was on this letter when you issued it in 2020, right?
It was.
Okay. So the very face of the document that you signed specifically states that it is not an opinion under 402, true?
No, that's not correct.
Specifically states it's not a formal Attorney General opinion under section 402.042 of the Texas Government Code.
It is not a formal Attorney General opinion
Okay.
under Section 402. It's very different.
Okay. Let's talk about formal opinions. There's a specific place on the Attorney General website for a formal opinion, is there not?
Opinions that are issued are listed on our website, yes. They were assigned KP numbers and they are accessible by the public.
They are signed KP numbers. At this time, Judge, I would move to offer AG Exhibit 6 after I provide a copy to opposing counsel.
If you have one more copy for us, we'd appreciate it.
I've got one more copy for the court.
I have no objection, John.
We'd still like to see it.
Yes, Judge.
Just so we can follow along. All right. Thank you, sir. Admit this exhibit into evidence. No objection.
And Eric, if you would publish and just stay on the first page. So up here in the top left corner, we've got opinion number KP 0322. True?
Yes, it says opinion number KP 0322.
Okay. And that is an opinion number that is associated with a formal opinion.
I have not seen the rest of this document, but I'm assuming that this has the form and shape of an informal opinion.
Okay. Did you state yesterday during direct examination that Ken Paxton doesn't have a hand in signing or dealing with formal opinions?
I don't believe I said that, no.
Okay. So you would agree that he does pay attention to what he signs and what he issues on his office letterhead, correct?
He is required, or, well, I should say, he has a practice of signing formal opinions himself.
Okay. And that opinion has his name on it, true?
I cannot see it, but I would be welcome to look at the signature block.
Eric, would you flip back to the signature line? Okay. You see Ken Paxton's signature on that opinion, right?
Yes,
Okay. He has to sign these formal opinions, does he not?
I believe that is the practice of the office.
Unless he's been recused, in which event Jeff Mateer would sign the formal opinions, true?
That was the practice of the office.
Now, I want to talk to you about the opinions in this case. Originally, Ryan Vassar drafted the the informal guidance letter with regard to foreclosure sales, correct?
Yes, the informal opinion that was issued on August 1st, he did draft the initial draft, yes.
Now, the way that that letter ruled was essentially that you didn't attack the 10-person restriction from the executive order, right? You just said that judicial foreclosure sales were accepted from the rule and could go on with that restriction.
I would need to see the document to refresh my recollection on the precise contours of the opinion.
Eric, would you pull up Exhibit 192? I mean, Mr. Banger, you drafted this opinion, did you not?
Well, Mr. Vassar drafted it, and I provided edits and corrections to it.
So you're familiar with the content?
I was 3 years ago.
Okay. Well, if you take a look at it, you would agree that it ruled that foreclosure sales could still go on despite the fact that there was an executive order restricting public gatherings outside to 10 people. True?
Please go to the next page. There were very limited circumstances under which foreclosure sales could proceed, but we were subjecting those to the hard 10-person cap.
I mean, you testified with regard to the subject matter of this yesterday, didn't you?
I did.
So you would agree that you said that despite the fact that 10 people at max can gather in public, foreclosure sales can still occur, true?
That misrepresents the opinion.
Well, if there are, you said that foreclosure sales could still go on, did you not? Is that not what that opinion says?
No.
It doesn't seek to invalidate the 10-person rule, does it?
You need to go to the next page of the opinion.
Go to the next page, Eric. Thank you.
The second full paragraph on page 3 has operative language.
Elaborate on that.
Pardon me?
Tell us about that.
If a foreclosure sale is subject to and not exempted from the 10-person attendance limit imposed in Executive Order GA-28, it should not proceed if one or more willing bidders are unable to participate because of the attendance limit.
Okay. So, how are you saying that when Ken Paxton asks you to change the opinion, that it is contrary to precedent and the position of the Office of Attorney General at that time?
It made the ability to proceed with those types of sales more restrictive under the COVID limitations than our previous draft would have.
It made it more restrictive?
Yes.
Right. Which means that, in a sense, it benefited people that maybe didn't have their jobs at the time and didn't have money to pay their mortgages off. True?
I do not know who this was benefiting. At least at the time I was writing it, I didn't know who it was benefiting.
Did you lose your job during COVID, Mr. Bangert?
Say again?
Did you lose your job during COVID?
I did not.
Did you struggle with the ability to pay a mortgage during COVID?
I did not.
You would have to agree with me that many people did lose their jobs during COVID. True?
I understand that that did happen.
Okay, and as a result of losing their jobs, many people probably couldn't afford rent and they couldn't afford their mortgage, right?
I also understand that financial institutions were suffering because of restrictions on their ability to foreclose on their loans.
Objection non-responsive.
May he please answer the question, Your Honor? Let it be allowed to answer.
Is that an objection, or are you just making a comment?
It is objection.
It will overruled, but let him clearly answer the question, but answer the question directed.
Yes or no? My question was yes or no. Could that affect people and their ability to pay their mortgages and their rent?
Could what affect them?
a ruling that foreclosure sales, or excuse me, that COVID was in existence.
COVID was in existence at that time.
And it caused people not to have money and not to be able to afford rent and not to be able to pay their mortgages. True?
I believe the economic disruption caused by COVID had some of those effects.
Okay. And the job of the Office of Attorney General is in part to protect the public. True?
The Attorney General's office is a sacred trust, and it's always to be used for the public benefit.
Right. Now,
All of the public.
Eric, could you publish Exhibit 119 again? This is your memorandum of what happened with regard to the foreclosure opinion. And you stated in Exhibit 119 that you were not certain why Ken Paxton wanted this foreclosure opinion issued. True?
There's no exhibit on my screen.
119, Eric.
May we see it, please?
I think it's been entered, Rusty.
I said, we don't have it.
Oh, I understand. Eric's pulling it up.
We don't have a copy.
It's y'all's exhibit.
Is it in evidence? I don't think it's in evidence.
It's in evidence, Judge. I've already referenced it during this examination.
He submitted it earlier. You didn't object, I believe. Oh, I believe that's the case.
If that's
Yes,
the case.
no, this I
If
recognize.
that's the case for an error, but I don't think we had it marked as in evidence. Thank you very much.
Yes, sir.
You stated that you were uncertain why Ken wanted the foreclosure opinion issued. True?
He had provided me a rationale.
It's a yes or no. You said in this memorandum right here, you were uncertain.
I was uncertain.
Okay. Now, you did not include the fact that Ken Paxton was texting you all the while you were editing and drafting that report, did you?
I don't believe I mentioned text messages in this document, no.
And yesterday you told all the senators that it was contentious between you two on the phone at some points, did you not?
Oh, I don't recall saying that.
Okay. So it was calm and collected the entire time.
It was not calm and collected the entire time.
Okay. Well, you stated to them that you were objecting vehemently over the phone with Ken Paxton, true?
I did not say that.
You were objecting to Ken Paxton, were you not?
I was having conversations with him in which he was frantically telling me to make edits, corrections,
It's
and
a yes or no
ultimately
question.
changes.
It's a yes or no question, Mr. Bangert. You disagree with Ken Paxton over the phone, true?
I had conversations with him about the contours of the opinion.
Okay, so you're not saying you disagree with him then, are you?
I was trying to understand what he wanted as his subordinate.
Okay. You didn't mention text messages yesterday, did you?
I did not.
All right. Eric, if you would flip to AG 1003 for me. Now, Mr. Bangert, you stated on direct examination yesterday that, quote unquote, Ken Paxton was acting like a man with a gun to his head. Did you not?
I did say that.
Okay. Now, looking at the last set of text messages here, if you'd flip to the last page, Eric. I'm just going to read from the exhibit. Thank you again. I can't express in words how much I appreciate your work, especially over the weekend. I am grateful because I feel like hundreds of people will be protected from harm and maybe devastation. You and Ryan deserve all the credit. Thank you. I hope that your Sunday is relaxing and enjoyable with your family. He texted that to you that day, didn't he?
12:19 on Sunday. Yes.
Okay. Now, did you mention that to the House Board of Managers when you were interviewed about this case?
I don't recall if I mentioned this text message.
Did you mention these text messages in your interviews with Mr. Harden or Mr. DeGuerin when you were preparing for testimony and trial?
I don't see why I would have.
Okay. And did you include it in your memorandum to Ryan Vassar that was produced?
There's no reason why I would have.
No reason to include a text message of him showing gratitude and why he wanted to have this foreclosure opinion worded the way he did?
I don't believe this was what he actually, I don't believe that he was telling the truth.
Well, there's
here.
certainly not a text message from you in these texts objecting or saying that you disagree with Mr. Paxton, is there?
I do not agree. I do not disagree with him here.
You don't disagree with him here.
I do not state it in writing here.
Okay. And you signed the opinion that was ultimately issued in this case, true?
I did sign it.
And that opinion has no binding effect.
It is a persuasive opinion.
Persuasive at best.
Persuasive opinion.
Okay. Did you tell the FBI about these documents?
I believe they were provided to the FBI.
Okay. We just didn't get a copy of them until today?
I did not have them in my possession.
Oh, okay.
They were in the possession of my counsel who found them.
Did you delete
recently.
your texts?
No.
So you would have had them on your phone, true?
No, I did not intentionally delete my texts.
Okay.
My texts are no longer.
Your texts
I no longer
were
have access
deleted,
to
yes
them.
or no?
Gentlemen, don't talk over each other.
Your texts were deleted, yes or no?
I no longer have access
It's a
to
yes
texts.
or no question.
I no longer have access to texts past 1 year.
Okay. So in the year, you didn't think to take screenshots of these?
Excuse me?
You didn't think to screenshot these messages?
These were screenshotted back in 2020.
Okay. You just didn't keep a copy.
I did not.
And you're not going to sit here and tell us that you know that the foreclosure opinion ultimately affected or benefited Nate Paul, are you?
Oh, I believe it did affect and benefit him.
You have no personal knowledge of that, do you?
I have since learned that it did benefit him.
You wrote in that memorandum that you learned through the Austin Statesman, did you not?
May I see the memorandum again?
Eric, would you please pull up the memorandum? That's a newspaper, correct?
The Austin American Statesman?
Yep.
Yes.
Okay. So you got your information from a newspaper, did you not? If we're believing your memorandum.
If I could see my memorandum, I can tell you.
Oh, Eric, would you? 119, Eric. Thank you. I think it says on the following week, on August 4th, the Austin Business Journal, I stand corrected. The Austin Business Journal reported that World Class had placed several properties into bankruptcy.
So it did.
Are you aware of when the foreclosure was supposed to take place?
I was not aware of any foreclosures of Nate Paul properties when I was writing the opinion.
No, I'm talking about after. I'm talking about August 3rd and August 4th. Were you aware?
I subsequently learned that that was taking place.
That the foreclosure was supposed to take place on August 4th.
That I don't know for sure, but it would have been the statutorily appointed date, whatever that was, in 2020. And yes, now that I'm looking at my document, I do say August 4th, so that would have been the date.
Okay. May I approach the witness, Judge? Just to hand him
Yes,
the
you may.
document. And Judge, at this time, I would offer AG Exhibit 295.
Any objection?
May I have just a second? I'm sorry, Judge. Thank you. No objection?
We'll enter, what was the number on that? I don't have the number on that.
295, Judge.
Enter 295 into evidence.
Eric, would you mind publishing AG 295? That is a letter from Sheena Paul to the judge regarding the the foreclosure proceeding occurring the next day, dated August 3rd of 2020, correct?
This is executed by Brian Elliott.
Attorney for World Class, right?
I assume so because it has World Class's, one of their property names at the top of the letterhead.
You would agree that this document has the letterhead of August 3rd, right?
It is dated August 3rd.
Now, you were not present in the district court when this document was filed, were you?
No.
So you have no idea what impact it had on the district court judge in that proceeding, do you?
I have not talked or spoken with Judge Campbell about this, no.
Now, the very next day, the day that the foreclosures are supposed to occur, you find out that a bunch of Nate Paul properties are world-class properties are put into bankruptcy, right?
That's what the Business Journal reported.
Okay. You've been in civil practice for quite a long time, true?
Over a decade at that point.
You are very, very aware of what happens to properties when you file bankruptcy, are you not?
I was not a bankruptcy practitioner.
Well, surely you're aware that when you put a document, you file bankruptcy on something, it causes a motion to stay, does it not?
There's an automatic stay that's applied based on my recollection.
There you go, which would prevent any type of foreclosure sale, would it not?
Again, I am not a certified bankruptcy practitioner. I know that there are exceptions to that. I can't even begin to speak to the legalities of these properties or how those would have applied in these cases.
Well, you knew a lot of law, on direct examination with Mr. Harden, and now you don't know about bankruptcy proceedings?
Mr. Harden did not ask me about bankruptcy proceedings.
You had no problem putting in your memorandum that the properties went into bankruptcy.
The properties were going into bankruptcy, that's correct.
Okay.
They were going to foreclosure.
It's possible that the bankruptcy filings did not, or those are what prevented the foreclosures. True?
I don't know.
Okay. Well,
But I think it's interesting that World Class submitted a copy of our
objection to non-responsive.
opinion.
Objection to non-responsive. May I approach the witness, Judge?
Yes, you may.
I would like to offer AG exhibits that I've handed to both opposing counsel as well as Your Honor. I believe it's 262, 265, 275, and 283.
Hold on, slow down. 283, 275, 265, 262?
Yes.
I can shorten this a little bit. If he represents that these are their exhibit numbers that were originally agreed to, that we said we would not object to any of your exhibits.
Okay.
If they're covered by that objection, if they're covered by that agreement, then we have no objection.
Are they covered?
They are covered, Judge. Well, take that back. No, they're not. That's why I intend to offer right now. We have not previously agreed to these.
I understand. Just give me a couple more minutes then. I don't care. No objection, Your Honor.
Can you just clarify for the record, we have one with a number and what the other numbers are? You may have the copies back.
So for purposes of the record, we're offering 262, 283, 275. I only gave you, and then also 269.
No objection? 269 was a new number from the one you repeated back to me?
Yep.
Just want to be clear.
269, 275, 283, and 262.
I think I said 265. You repeated what I said. I was incorrect. It's 269.
Okay.
There's been no objection? I believe they said no objection. Mr. Harden, you said no objection, correct? Yeah.
Sorry, Judge.
Please enter those documents into the record,
Just gonna okay. Thank you.
into evidence. Excuse me.
May I approach the witness, Judge?
Yes, you may.
There's got to be something.
These are all bankruptcy filings by Nate Paul and his attorneys made on August 4th and August 5th, okay?
Say so.
All right. Now, if these bankruptcy filings were filed on August 4th, the date that the foreclosures were supposed to occur, that would stay the foreclosure sale, would it not?
I don't know.
You don't know.
Perhaps.
So it's possible that Ken's issuance of the informal guidance letter didn't cause the foreclosure sales to go away. It's possible.
I do not know what effect that letter had
Okay.
on the foreclosure sales.
Are you a Trump fan?
I'm sorry?
Are you a fan of Donald Trump?
I voted for President Trump.
Okay. You're a staunch conservative, are you not?
I am.
Are you aware that only a week after you guys issued this opinion, he issued an executive order that basically mimicked the attitude towards foreclosure sales?
I'm not familiar with that executive order.
Okay. And so that brings us into the fall of 2020, right? August, September?
September is the beginning of fall.
Okay. And you didn't really have any contact with issues regarding Nate Paul from August of 2020 up until September 28th, right?
Oh, I disagree with that.
Well, you weren't working on the
The
foreclosure
witness,
opinion.
please speak up when you're...
Yes, I disagree with that.
You were not working on the foreclosure opinion.
That was completed on August 1st.
Okay. You weren't working on MIDI.
Mr. McCarty had assumed responsibility for that.
You were not working on MIDI.
I was not working on MIDI at that time in August.
And you were not working on the open records request. True?
Those were finished.
Okay. So you were not personally working on any matters that involved Nate Paul at that time.
I was actively speaking with other members of the executive team about what was happening at that time, which was the desire to hire outside counsel.
So everybody, I assume, is on the 8th floor at this time, right?
We had COVID orders were still in place. I don't recall who was there every day. I was there every day the office was open.
And let's talk about that, because the OAG's position at that time was that everything should open up, was it not?
We wanted everything to be as open as possible, consistent with public safety and the governor's orders.
Even after you left the Office of Attorney General, your employees at the Office of Attorney General weren't even present.
There were some who were not present.
There were some. There were most of them that were not present.
My recollection was there were periods of time where large majorities of them were not working from the office.
Periods of time that postdated your employment at the Office of Attorney General.
I cannot speak to that.
Because you weren't there.
Because I was not there.
So that's not really inconsistent with the situation that was going on at the Office of Attorney General, was it? Yes or no?
That the attorneys were
Yes,
not
sir.
present?
Yes or no?
Oh, that had nothing to do with our policy.
Okay.
Nothing.
So you were not personally a part of the hiring of Kamek, were you?
No.
You found this out on September 29th of 2020.
That he had been retained by the Attorney General directly?
know that he was filing subpoenas with Michael Wynn.
Yes, I learned about that on the 29th.
And you're saying that that is the very point that it kind of stood out to you all what was going on, right? That was the tipping point.
That crystallized a number of things.
Okay. Now, when you say it crystallized a number of things, you did not have all the facts with regard to that investigation, did you?
I personally did not.
Okay. You didn't investigate that case, did you?
Was I... What do you mean by I wasn't investigating that case?
You didn't investigate the referral that was given by the Travis County District Attorney's Office, did you?
I was not the primary responsibility for that.
Everything that you took with regard to that investigation came from Mr. Penley or Mr. Maxwell.
No,
Those were the people responsible for investigating it, were they not?
they were responsible.
Okay. You were not responsible.
That was not part of my responsibility at that time.
Okay, so you weren't responsible. Now, despite that fact, you went to the FBI on September 30th, correct?
I did go to the FBI on September 30th, yes.
You went to the FBI without talking to Ken Paxton first, true?
Oh, I talked to him many times prior to that.
You didn't talk to him about the fact that you were going to go to the FBI, did you?
We did not talk to him. We did not tell him we were going to the FBI immediately prior to going.
Right. So when you and Mr. Harden were talking about the conversations you had with Ken Paxton about the fact that you wanted to talk to him, that was all after you had already gone and reported your boss to law enforcement, true?
The text messages that we reviewed today were sent after we made our good faith report.
Okay. So you did not take the time to hear his side of things out before you went to law enforcement?
I disagree.
And at that point, you took it upon yourself to send a letter to Brandon Kamek as well, did you not?
If I can recall correctly, I was the one who did send the email containing Jeff's letter. Again, I'm stretching my memory, but I think I was the one who sent it.
Okay. Now, prior to doing that, you talked earlier about a set of text messages. I would ask to admit to publish House Board Managers 225. Eric, would you? It's been admitted, Judge.
And Counselor, we're going to be going to the lunch break. I've gone a little longer, a few more minutes. Do you want to break now, or do you want to continue for
I'm
a few
fine
more
right
minutes?
now, Judge.
Is it good for you now?
Yep.
Okay, we'll break for lunch now.
Your Honor, I apologize. Can I raise one issue? I apologize, Your Honor. Can I raise one issue before we break for lunch?
Yes.
That may just help speed things along with this witness. You admonished Mr. Harden at the beginning of the day that if there were any statements that Mr. Bangert had provided that we haven't seen, that he was to turn them over to us. The witness has testified that there were actually 2 interviews that he gave to the House. We still don't have any information related to those. To the extent that there's work product mixed with that, I think they can redact that and provide us the statements. But I just request that we get those over the lunch break, and that may allow us to not have to recall the witness later.
Just continue to look during lunch break for those documents if you have those.
Thank you very
And
much.
if you do, turn those over by the end of lunch.
Certainly. We do not have, but I'll continue to be sure. Thank you.
We will return at 1:10.
I don't either, because this is our whole theory. I wonder if he doesn't know that they, well, no, this tells him. I was about to say maybe he didn't know they tried to use it. He may not know that what happened is, I think, we have to check, I think she reserved her opinion. She didn't make a ruling after the hearing that day. And I think they got the sense that she was going to rule against them. And so they went and declared bankruptcy. But I'm not sure how that helps them.